check on 2. 2, check on 2.
Kenya's constitutional rebirth. It was created to safeguard the transformative promises of the Constitution by being a final arbiter of legal issues.
The Supreme Court was established after the promulgation of the Constitution of Kenya 2010, following a clamor by Kenyans that they required an apex court that could settle with finality certain complex matters like with expediency, like the presidential election dispute. The Supreme Court has also settled many issues involving the application and interpretation of the Constitution, which is an original mandate given to the Supreme Court.
There were so many challenges in terms of democratic governance, which started, of course, with the Independence Constitution, the 1964 Constitution, which then was amended. And with the Constitution amendment starting from 1991, the introduction of multi-party, there were amendments in 1997 to open the space for electoral democracy. A failed referendum in 2005 when Kenyans said no to a new constitution, to the elections of 2007. And as a result of that, they created what they call the Agenda 4. And one of the agendas was to create a new constitutional dispensation.
The entry of the Constitution 2010 of Kenya came with a fundamental shift in the constitutional architecture of the country. The Supreme Court of Kenya, as the apex court, was established to inject new judicial philosophy and develop indigenous jurisprudence that aligns with the new constitutional provisions.
I was lucky to have been appointed a member of the Constitutional Review Commission of Kenya. Kenyans were particularly concerned about the judiciary at the time, that the Court of Appeal as the final court at the time was not sufficiently capacitated to handle matters of national importance with finality to the satisfaction of Kenyans. They also said they want a court which would be above the Court of Appeal at the time, a court that would then have the confidence of Kenyans that when you've exhausted the legal mechanism, you receive justice at the highest level, which would be the Supreme Court. So that was the history and the reason why the Supreme Court was created.
The Constitution under Article 163(1) established the Supreme Court as the apex court in Kenya with the following mandate. A. Exclusive and original jurisdiction to hear and determine presidential election petitions. B. Hear appeals from the Court of Appeal on both matters of general public importance and interpretation and application of the Constitution. C. Hear appeals by judges from tribunals formed for their removal from office. D. Render advisory opinions. And E. Determine the validity of declarations of a state of emergency. Following a competitive and open recruitment process by the Judicial Service Commission, the inaugural bench of 7 judges of the Supreme Court was appointed on 16th of June 2011 by His Excellency President Mwai Kibaki and assumed office on 26th of August 2011. Over the years, the composition of the bench has undergone changes. Once Chief Justice Dr. Mutunga's term in office came to an end, Chief Justice David Maraga was appointed thereafter in 2016 and served until 2021.
I, David Kenani Maraga.
Also, following the exit of Deputy Chief Justice Dr. Nancy Barasa, Lady Justice Kalpana Rawal was appointed in 2013 and served until 2016.
I, Martha Karambu Kome.
The current bench is under the leadership of the Chief Justice Martha K. Kome, who was appointed in 2021.
The judiciary required massive transformation of its operations for it to meet the tenets of that constitution. My predecessor, Dr. Will Mutunga, started that with the blueprint of judiciary transformation framework, and I laid the basis. When I took over, I built on what he had started, enhancing service delivery and ensuring that parties are able to access justice freely.
I think we are the best performing court. We are almost real time. When you file a matter, especially an application, it will be handled and disposed of within 3 months. The petition of appeal will be disposed almost in a year's time.
Because of our refined jurisdiction, since 2011, when we first sat, there's been filed a total number of 680 cases of all natures, applications, petitions, and advisory opinion. As we speak today, we have settled them except for 41.
At the beginning, we didn't have advanced technology, ICT, that we have now. Everything was manual. Now we do even virtual hearings, and we are able to dispose of cases quite fast.
The court has done a great work. The foundation that was laid by the pioneer judges and that continues to be built by the current judges ought to continue. The kind of jurisprudence that we are churning out that are cited across the world ought to continue.
Over the years, the Supreme Court has delivered landmark judgments, developing a rich and indigenous body of jurisprudence that reflects the spirit of the Constitution while addressing the evolving needs and demands of the Kenyan society.
In the revenue allocation case, the Supreme Court clarified the role of the National Assembly. The Supreme Court clarified the role of the Senate. The Supreme Court clarified the role of county governments.
BBI report itatekeleza mikakati ya kuboresha maisha ya Wakenya wote.
The Building Bridges initiative case to amend the Constitution was very emotive. The country was divided. It had brought a lot of tension, and the Supreme Court was able to determine it with the finality.
The Supreme Court's decisions, for instance, in the areas of environment and land have been clear. I refer to decisions such as Mitubel and Kenya Airports Authority, for instance.
The 2017 Supreme Court decision made it very clear that unless the electoral process was done in accordance with the Constitution, the court would set it aside.
We have made decisions on the removal of judges, separation of powers, or when it comes to advisory opinion that we've given.
We made a landmark decision in criminal law where we declared the death penalty, the mandatory death penalty, to be unconstitutional. Relating to family law, many people call the come we stay a marriage, when in actual fact it is not. You are not married, you have purchased this property together, you are no longer together. What then happens? So it was a lacuna in the law which the Supreme Court has settled.
There is something called collegiality. Collegiality means aspect of each one of us contributing as much as they must to the determination of the case, and the rest of us respecting each other's ideas, and the fact that the decision has to be the decision of the court, not of one, not even of the 5, but of the 7.
The journey has not been without its challenges. But through it all, the Supreme Court has remained steadfast in its commitment to justice. It has faced criticism, withstood pressure, and emerged stronger.
The first challenge is the number of judges in the court. A few years back, the court faced a challenge. Judges had retired. One judge was available to sit, so suddenly we had 4 judges. That is exceedingly dangerous.
Then we were swamped with a bewildering array of legal issues, of constitutional issues. What would be the appropriate date to hold the first general elections under the 2010 Constitution, for example? The biggest challenge we face today is unwarranted criticism. We do not get positive criticism that can help us develop. All we get is our insults in social media, in the mainstream media, and that's something that can weigh down on human beings.
The time for hearing is so short, the evidence voluminous, and then there's preparing submissions, and finally for the judges to retreat. Sometimes we retreat only for 2 days. We should have at least 60 days, minimum in my view, 45 days.
The Supreme Court has no home, and it is our priority to build a Supreme Court. We are seated in an old building, the museum, where we have no space. So we have plans to build the Supreme Court of Kenya.
The court strives for excellence in its case management. From scheduling hearings, settling timelines, managing case documents, facilitating communication between parties, and ensuring that cases move through the system in a timely manner. The court has also harnessed technology to improve on its efficiency and effectiveness.
The Supreme Court is basically a virtual court. We do not have physical hearings, so we have a virtual court for all the hearings, unless there is any need to have a physical court. And I stated that the physical court ordinarily is during the presidential election petition. The rest of the matters, and virtually anybody can log in from any part of this country. We have a virtual customer care desk. You do not have to come to Nairobi or any of the sub-registries to get information about your matter. You can virtually be assisted by the staff from the registry. The e-filing, you do not have to come to Nairobi or to any of the registries to do your filings. You can virtually file them through the e-filing or the CTS system that is in operation within the courts.
To ensure that cases, once filed, the law gives us 90 days within which to settle them. And therefore my responsibility is to ensure that the cases are settled. If not within the 90 days, and thank God we have settled many long before the 90 days, then it must not go beyond 90 days by too long.
You know, I tell people who are from outside of our country about the extent to which the judiciary has embraced technology. And they don't believe me until they become consumers of justice. And they're like, Chuti, this doesn't even happen where we come from, you know, and that's supposed to be the developed world. So I can tell you, the entire judiciary technologically is doing so very well.
Yesterday I saw a post, a forum at which I believe Justice Mohammed Ibrahim will be speaking. I think we would like to see more of those. I think we would like to see more visibility of judges of the Supreme Court within an academic setting in which they speak about matters of public interest.
The judiciary badly requires financial autonomy. So it provided in Article 173 for a judiciary fund to be established to enable the judiciary to run its affairs.
Everyone around us tell us what we've done right and what we've done wrong and what we can do better.
The judiciary is one of the 3 arms of government, not the 3rd arm. There's need for the other two arms to consider the judiciary as part of the government.
We have not brought on board the general public. Courts will play their role, but theirs will be limited. To what extent can a Kenyan, for example, feel that they are part and parcel of what is happening?
As we celebrate these 12 years of this court, give us feedback. We shall introspect, and we can only make this court better and make our judiciary better for the sake of the great people of the Republic of Kenya.
Kenyans have been very supportive. As one of the levels of court in the judiciary, it has strengthened the independence of the judiciary. So Kenyans should know that the judiciary is there for them, the Supreme Court is there for them. Our doors are open, and with God's blessing and support of all Kenyans, we would like to continue discharging our constitutional obligations so that Kenyans enjoy their basic human rights and the rule of law.
It is that one court where you know you have one option, which is to get it right, to do it right, to stabilize the country.
There is a lot of hope of even getting Kenyans embrace all these principles that are enunciated in the Constitution. The principles of good governance, the principles of respect for one another, the principles of non-discrimination, because these are all principles.
Good morning. Good morning. We can start. And honorable judges of the Supreme Court present, honorable delegates, as we come to the last day of this celebration, the conference, we will recap on what happened yesterday. We had 4 sessions yesterday. We had the first session that we began on constitutional interpretation, where we dealt with electoral jurisprudence, and there was a discussion on pathways to constitutional amendments. We discussed about the BBI case and the basic structure doctrine on the first presentation that was chaired by Honorable Justice Smokin Wanjala. We had the second session on socioeconomic rights that was chaired by Honorable Justice Isaac Lenaola. And in that we had a little bit of discussion on the responsibility of the state to take legislative measures to ensure the rights are enjoyed by citizens. The afternoon session was the criminal law jurisprudence that was chaired by Honorable Justice, Lady Justice Joki Dungu. And we spoke about many areas of criminal law, including the judicial discretion in sentencing and the rights of victims. And finally, the last session was on the evolution of family law. We spoke about Article 45(3) of the Constitution, about rights in marriage before, during, and at the dissolution of marriage. And basically that is what we covered yesterday. I take this opportunity to welcome you all to today's session. We'll begin with technology and human rights. The panel is chaired by Honorable Justice Isaac Lenaola. The panelists are already seated and ready to proceed. Their bios are in the program. We have Mugambi Laibuta on page 35, Stephen Kiptines, page 39, Robert Muthuri, page 42, and Justice Marvizenge is absent, but we will proceed with the panelists who are present. Most welcome, Judge.
Thank you very much, and good morning, everyone. Welcome to this session number 7. In this session, we shall delve into technology and a bit of human rights. And the question we shall address is, how do we navigate emerging challenges in a digital age? And in answering that question, my panelists will look at the question of how do we as courts, and as the Supreme Court particularly, balance human rights and the advent of technology. We shall also address the new animal in town called artificial intelligence. Over the last couple of months, at least within the Kenyan judiciary, we who are in the space of technology have been asking ourselves the question, how do we manage artificial intelligence so that it becomes useful and not harmful to our processes? In the United Kingdom, for example, the Chief Justice has put together a team that is working around guidelines on how judges should use artificial intelligence and how advocates should use artificial intelligence. You will be surprised, or maybe not surprised, to know that a judge in Brazil last year was caught, quote, quote, caught over using artificial intelligence in writing his judgment. And the problem that arose was that I think he used ChatGPT, it wrote the wrong judgment, not based on the facts or the law that was available to that case. How do we as a country and as a judiciary manage artificial intelligence in the context also of access to justice? If already cut and paste had become a problem in our courts where pleadings from one law firm are used by another law firm in a cut and paste scenario, what about artificial intelligence? How far can we go in its use? Another of the questions my panelists will address is data protection and privacy rights. How does data protection and the adoption of technology affect privacy? And lastly, we shall, as a panel, generally address technology in judiciaries, and then I guess when our colleagues from across Africa speak, they'll give us their experiences. And so we have organized ourselves in the following manner. Dr. Robert Kirinya, who's on my immediate left, will go first. He has a short presentation. Then we shall invite Dr. Alfred Mavizenge when he arrives to go next. And then third will be Mr. Stephen Kiptines. And lastly, Dr. Mugambi Laibuta, in that order. And then we shall open it up to you for any comments and questions. And then we shall close this session, which I believe would be extremely useful to all of us. So let me now invite Dr. Robert Kirinya Mudhuri to make his presentation. Robert.
Allow me to rest on the protocols that have already been observed. A very good morning to you all. It's a pleasure to be here. I do not take it for granted. We are literally resting on the shoulders of giants that we've seen in the industry, right from when I was a second-year law student doing my clinicals under the justice to my right in Meru. And we've seen the journeys that you've walked, and we do not take it for granted. So as we introspect today on the third day, I will ask, please have my presentation here, or I can reference it directly. Thank you. As we introspect today, I think maybe the last 2 days have been more about looking at what has happened in the past, and maybe today we can look a little bit to the future. And even as I say that, let me say that the number 12 is special because it represents, to our culture as Christians, we know about the 12 tribes of Israel, we know the 12 disciples, but in Revelation 21, there's the 12 gates of heaven, each guarded by 12 angels. So there's a heavenly structure, and it could represent the maturation of the court, that we are celebrating 12 years, that we are now of age, and how are we going to be looking forward to the future. So we're here to talk about technology, more introspecting, more forward-facing. Thank you, please. Next slide. The context was set very well, especially yesterday's session with Justice Njoki Ndongo on criminal justice. My concerns would be very brief so that I can move on more to the technology issues. The court ought to be a safeguard to ensure, one, that we do not extend the digital divide. What does that mean? That means that when we're instituting virtual courts, when we're instituting digital services in government, we do not lose the indigent, the elderly, and others. Can we think about how are they going to be able to access these services as we move on to a digital space? What does the right to a public trial, the right for an accused to confront their witness, their right to be present mean in a virtual court setting? I've written an opinion earlier in the year to the now registrar in charge of automation, and I think there are some challenges there that need to be introspected on as we move forward. On digital rights, what does it mean, the right of assembly, the right to privacy, the right to security in an online space? We saw the Gen Z movement and their organization online that then came to the ground. How do we safeguard and expand these spaces, moving from the traditional civil rights to now digital rights? And same thing can be said to right to liberty. There's a narrow line between legitimate surveillance and online censorship. Do we feel safe to have conversations online? I've heard it said that with 3,000 shillings, you can, and talking to the right people, you can track anyone. Is a court understanding that, yes, there is a right to surveillance, and there's all this, I think it's part 4 of the Cybercrimes Act 2018. Yes, investigation procedures. How are we preserving data? Is it being overreached? And my colleagues will talk about data protection as well. Someone was asking me, what is this thing with EMEA numbers being shared with KRA? Does KRA need an EMEA number to check that a phone has been tax compliant? Does that mean there's a total complete breakdown in procurement and them being able to supervise how sellers are importing and selling their phones? Does it have to get to the point where they need an EMEA number? Can that, the data protection principle of purpose limitation, data retention periods, how are they going to supervise that? A young lady yesterday suggested to me that maybe we should have a tribunal on issues of legal technology, because it seems that there needs to be a bit more thought put into how we are, figuring out how we're going to be regulating products and services online. And I did hear it mentioned yesterday a lot that we're in a constitutional dispensation. Criminal justice is still held in the past. But the Cybercrimes Act is a 2018 act. And yet it has been said that it was the 4th attempt by Parliament to criminalize libel, right? So we do need to move forward. We can move to the next slide and think harder about these issues. Now, the challenge is, and first to laud the judiciary, prosecution as well, in instituting case management systems. We do have a juridical process that starts with investigative agencies. So the National Police, IPOA, EACC, etc. Then it comes to prosecution, then the judiciary, and then correction and probation. Now, those two stand out there. Prosecution with the Uadilifu system, judiciary with the case tracking system have been able to digitize. But they are struggling because upstream with the investigative agencies, for instance, with the National Police, they do not yet have a case management system. So we're struggling with unique identifiers. We're struggling even to establish a proper system of being able to identify persons, the Huduma number, the Maisha number, the second generation ID. ODPP arrests people, cattle rustlers that have never gotten an ID. How do you take that person through the process? And so the case management systems right now are either non-existent, and the ones that are existing, I do know there's relationship between Uadilifu and CTS, and we're trying to strengthen that, but they're largely silos at the moment. Next. So we do need, with legal informatics is a young field, maybe legal informatics is define ways to solve the IT law misalignment so that IT can be a critical part of how we do law. Next. So, and that is happening at several levels. There's a lot of activity. So I do remember Captain said to keep it very simple. And at the very basic level is where we're trying to just organize legal text digitally. and things like document automation come in, etc. XML representation, I'll just refer you to our award-winning law reporting website. They do use XML, and that is how they're able to structure, for instance, the relationships between, oh, this case was overruled by that case. I would invite you to see the new version of the website. It's fantastic. And being able to demonstrate that this section of the law has these related cases on it. And that way we continue to structure digitally the work that we're doing. So essentially this is all AI. Then the third step is reasoning. Now that's where the logic comes in. And logic defines the reasoning behind the system so that we're able to relate the different issues. And finally now, in defeasible logic, the last step is where you'd think you'd have automated judges in the future because the system will be able to do that entirely by itself. And large language models, the LLMs, so the software behind ChatGPT, etc., is giving us more access to such possibilities. But all of this is work in progress. But at the ground level and at the second level, a lot is already happening. And I think the Supreme Court, more acting like giving direction to the judiciary, should explore a lot of these technologies. Next. And so when I say a dictionary, as I said, you can represent a person in a system, or you can represent a case in a system, you can represent a report. An OB report is just an OB report. So you'll have person A, and you have their ID, maybe their age, etc. Person B, same thing. Person C, that's fine. Next is a taxonomy. So we understand dictionaries. Dictionaries is a word, has etc. meaning. A taxonomy now starts to bring in this tree structure, trying to show a little bit of the possibilities. So this is actually a case that I'm currently doing because I've decided to take up cases to really understand what is happening. This is a pro bono I'm doing in Makadara. So you have two assault cases. You have complainant A and complainant B. And the other case, you have complainant B and complainant C. The first case was reported September 28th last year. The next case was reported December 15th of 2023. Next. Only through an ontology can you be able to understand that actually person A and person C is the same. Person A reported a case against person B in September. On the same fact pattern, person B went and reported person A in December. But now the system has captured two separate cases in two separate courts, and I've gone and made an application for, at the very least, these matters to be heard concurrently, because we couldn't consolidate. And the ruling was that if my rights have been abused, my client's rights have been abused, I should go to the Constitutional Court. And then, unfortunately, the original complainant couldn't afford bail like the accused in the first case. So she ended up in remand prison for 4 months. So then we go and do decongestion and say that we are trying to clean up the system. But if we have proper systems, then this would never have happened. They would never even have been able to be arrested in the first place. Because what would have happened is in Uadilifu, when complainant B came to register the case against C, then Uadilifu would have been able to flag, oh no, wait, C looks like A. Even if it's Mr. Uadilifu, with the CTS relationship, CTS would be able to say, no, actually, C and A look the same person. Let's think again about the decision to charge here. And that is how we can have a system way of thinking where then we don't allow for other institutions to abuse the court process, because for me it's very clear that that was an abuse of the prosecutorial process in it. Next. So the way forward, in short, as I've said, is just let's entrench system thinking. There is a lot of effort. This is a paper wrote in 2019 about how blockchain is instituting alternative dispute resolution. So in blockchain and in cryptocurrency, they have these things they call DAOs, distributed autonomous organizations. And those organizations are meant to really allow people to build applications and to trade. Then they realized, oh, we need a judicial system here because we can't now start sending people to court. And this paper explores how it failed, but that there is an attempt to create online dispute resolutions that are largely sort of independent of the judiciary as we know it. And I think my invitation is for the judiciary to come and be part of this process with technology. And so with transparency and accountability, those are really the things that we need to be using technology for. Thank you very much.
Thank you, Robert. I'd ask my panelists to make this simple for us, because not all of us understand deontic logic, ontologies, normas, robotic judges, but I think we are heading there. So Judge Karanja, don't panic. We shall settle at some point. Thank you very much. Let me now invite Kiptines to have his bite at it. Kipti.
Thank you, Judge. Good morning, ladies and gentlemen, justices from Kenya and from other countries. I'll be speaking about artificial intelligence, which is a very exciting topic. I'll keep this very simple as much as I can. There's a lot of material. But artificial intelligence was first defined in 1950 by a gentleman called Alan Turing, and he said that a computer should deserve to be called intelligent if it can deceive a human into acting like it is intelligent. And that's one simple way of defining artificial intelligence. Basically, the ability of machines or systems to act in a very a human-like fashion. There's a lot of move towards artificial generative intelligence, which is really speaking to how do machines act like humans. And there's a lot of issues, challenges, which have arisen as a result. And I was quite intrigued by the case of, referred to by the judge, where this Brazil judge relied heavily on ChatGPT. I never heard of a judge relying on it, unlike a lot of lawyers who do that. And I'll just speak to that issue right now. One of the challenges around relying excessively on ChatGPT, and I'll give you some statistics. In ChatGPT version 3.0, version 3 of ChatGPT was using approximately 1.75 billion parameters, data parameters. ChatGPT version 4 was using in excess of 2 trillion parameters. This is as at the end of last year. It's probably gone up by another factor of trillion, who knows. And it is that data that it will throw together based on what you ask. It is predictive. It is trying to predict what you're going to ask. And so when you use ChatGPT, as a lot of lawyers would, because it wants to give you an answer, it must give you a response, that's what you'd call, in technology terms, hallucination, because it cannot tell you, I don't have this, I don't know how to put this together. It'll give you some data. And so that hallucination of AI through ChatGPT will result in a lawyer getting a series of cases in his pleadings or in his submissions filed in court which are not factual. And so if you're relying on ChatGPT, especially if you're doing legal research, and that's one of the utilities of ChatGPT, then you must be able to verify the factuality of those cases that are allegedly reported in ChatGPT, or of the facts. And so that's one of the what I call the hallucinations of ChatGPT, which you need to be careful about in using it. But effectively, AI is meant to make the life of humans a lot easier. It's meant to facilitate a lot of what we can do in many sectors, including the administration of justice. Within the context of administration of justice, it can certainly support judges in analyzing large data sets, because you have to pour through volumes and volumes of material before you come to a certain decision making. And what AI can do for you is to reduce that into a very into a faster way, into a much more practical way than the human mind can do within the same time limits. It can enhance aspects around the administrative side of things, where litigation assessment. It can even guide in the criminal justice system how and why a judge should issue a certain kind of bail. In our case, we don't really have parole, but considerations around how an accused person needs to be treated within the criminal justice system. It can assist in development of virtual courtrooms. It can really assist in facilitating access to justice of those who don't typically have that fairness, that right within the use of traditional ways of accessing justice. So depending on how you choose to use artificial intelligence, it can be extremely helpful, but it can also be extremely risky. Let me speak to something that has been said AI assists in. AI will assist in debiasing. Now, there's bias in two ways. There's bias within the context of AI, and I mentioned that ChatGPT version 4 is using about 2 trillion parameters as of late last year. But what happens is, by the increase in the amount of data parameters, it increases the bias. It reinforces the bias. But the first bias I want to speak about is, it is trite, of course, that judges judicial officers ought to determine their cases in a very impartial way and remain as unbiased as possible. But it is fair to say, and research has shown, that there is an element of cognitive and social bias, which of course judges are aware of in the context of right to fair trial, impartiality. But interestingly, some of the arguments for AI, especially as a support decisioning tool, have been to say that it can help drill out the cognitive and social biases which you may have as a judicial officer, and therefore guide you on the areas that you need to be very careful, that you need to be conscious about. There's a research that I read that indicated that where judicial bias is likely to take place, and there's an element of what they call covariates, then you might take into account legally irrelevant issues which are deep-seated in you in making that decision. So if there's a way that artificial intelligence can be used to help reveal those biases so that you're aware and therefore take cognizance in that decision-making, in that trial, I think that might be an argument for why artificial intelligence can actually be helpful. It can help identify those instances of where traditional bias would arise. And some of this bias is typical. It's confirmation bias, again, depending on some of your social backgrounds. And so I think there's an argument that says it's possible using artificial intelligence to alert judges about what kind of interventions might be necessary within the context of bias to allow them to make decisions in a very objective and impartial way. So that's one aspect. The other aspect of bias in AI is what I mentioned earlier. How do you ensure that the data that you're getting from the artificial intelligence tool is free of bias? Now, artificial intelligence is created through humans who are inherently having certain levels of bias. So there's the bias that comes in from the humans who are creating it, and it's created by coders who write algorithms. So they already have their own bias. The coders who write this are not necessarily legal professionals, but because of throwing in a lot of data into this platform, you have to ask yourself, is there a level of bias that has been inherently coded into the platform that you might be using, to the artificial intelligence platform that you choose to use? And if there is, then it means that there already will be an inherent bias. As you look at this data, it will skew you in a particular direction. So AI in itself has skews, has biases, has omissions, has errors. And so the big question then is, how do you determine what those errors are in order to avoid them, in order to make sure that you're utilizing the artificial intelligence platforms in a way that is assistive. And one of the biggest challenges with artificial intelligence is, how do you prove that in trying to verify certain information that there is a human behind it? Now, I submit that one of the biggest challenges today to the use of technology in administration of justice is actually not artificial intelligence. In fact, it is something that's called deepfakes. Now, a quick definition of deepfakes: this is where you sort of overlay the voice and name, or sometimes just the picture and the voice of one individual to data that's already available online, so that you would take my picture, you take my voice, and it would seem that I am saying something that in fact I have never said. And one of the challenges I think that would be inherent for judges is, how do you apply the rules of evidence in the context of evidence that is generated? Either that could be a deep fake. You have one party saying this is a deep fake, and you have another party saying this was a recording. This was recorded by me as a human being. should the rules of evidence assist judges in taking a very dim view, a very conservative view of any technology evidence that is generated by a system to which you cannot put a human being? Because deepfakes 2-3 years ago were very obvious. They were seemingly, I can tell this is not the person, that this person didn't say these things. But today, deepfakes have become better because of generative AI, and they are able to perform a lot better. In other words, it's difficult for you, it would be difficult for you as a judicial officer to determine whether this evidence that's been presented by one party in a case as a technology-based evidence is indeed viable. Is it genuine or it's not? Should the judge therefore be erring on the side of caution as to say, I would rather discount this. The probative value that I should attribute to this should be of such an insignificant amount because we're not able to establish the genuineness or the human element behind it. And it will be very difficult for the party who's seeking to controvert that evidence to actually prove that this is not a deepfake. So that is one of the bigger challenges around technology-based evidence that's generated through deepfakes or by artificial intelligence. So there's also potential for algorithmic discrimination and the lack of transparent or the opaque nature of artificial intelligence. You cannot go back to the platform of artificial intelligence and ask it, why did you make this recommendation? Why did you generate this? When you ask ChatGPT platform a question, it'll give you an answer. It must give you an answer, regardless of whether it knows what you wanted, really wanted, or not. And hence, my suggestion that you need to really query it. Of course, it becomes better with time, but you need to query and ascertain the factuality of what it's telling you. And so, because you can't question the reasoning behind why it gave you what it gave you, and this is the realm of the courtroom. This is really where the red meat of the practice of law and administration of justice happens. And if you can't question it because it is opaque, it's just a set of data that exists, and when you query, it gives you something. So that, for me, seems to suggest that there's a bigger challenge around how much should we place reliance on artificial intelligence if we can't question why certain decisions were made. The judge referred to robotic judges. When a robotic judge makes a decision, is that decision appealable as an administrative decision or a decision of a judge? Are you able to query why that decision was made? Which really goes to the point I've just sort of tried to make. So obviously, in the context of AI, it should not be used to fundamentally alter or affect negatively fundamental rights of an individual. And if there's a situation where reliance on artificial intelligence will result in there being a level of bias within the application of the fundamental rights of an individual, then I suggest that it probably should not be relied on that heavily. I'm going to conclude by speaking about, I think, some of the things that we're still seeing happening and need to consider within the context of artificial intelligence. So, artificial intelligence, I think, is really a tool, not an oracle. It's not the be-all, end-all. And if you see it as an oracle, as the answer to all the questions that you're asking it, then you're likely to go down a very slippery garden path. You may know that ChatGPT, OpenAI, the creators of ChatGPT, have actually been sued by quite a number of authors for scraping their data and using their data without compensation. That's something that remains to be seen in terms of how it will be determined. I think there needs to be a consciousness the consciousness of the omissions, of the biases that exist within the context of artificial intelligence before heavy reliance is placed on it. If it's perceived as an assistive tool as opposed to something that is seeking to replace judges, I think there might be a lot of utility around how AI can be brought to the table. And finally, I think I'll conclude by asking how many of you judicial officers here have interacted with ChatGPT or other AI platforms, and what has been your experience? And the reason I ask this, and I'm not expecting you to answer me directly, of course, here and now, is to say, from your initial interactions versus your subsequent later interactions, if you've been interacting with it for, say, a year, then you will begin to realize that the tool will begin to understand how you ask, what you're asking. Really, it is predictive. It'll try to predict the next word and give you what it thinks you want. Do you think it has been useful, or do you think it has not been useful? Do you think judges can be replaced? Do you think, and that might be a dumb question at this point, but or judges shouldn't be replaced? There are countries like Estonia, there are countries like China, which are using robotic judges for certain administrative cases, for small claims cases, and those cases are determined without the input of a human, and then can be appealed to then a human judge to a higher level of court. But by and large, interestingly, a lot of those cases, when they get resolved, are not appealed. A very huge percentage of them are not appealed, upwards of 90%. So there is a case to be made for whether or not robots can replace judicial officers in certain kinds of cases. But I conclude by saying artificial intelligence is viewed as something that is assistive as opposed to replacing the work that you need to do within the context of verifying research, interpretation of procedural rules, rules of evidence. I think there's a lot more utility to be gained from it. Thank you.
Thank you very much, Mr. Kiptines. That is quite useful for us. Just a quick comment. As Mr. Kiptines was speaking, I asked this question to an app I have called Nova. I asked it, who is William Ouko? It answered in milliseconds. William Ouko is a notable figure in Kenya, primarily recognized for his role in the judiciary. He was appointed Chief Justice of Kenya and President of the Supreme Court in May 2021. Is it? So we have a new Chief Justice appointed by Nova. Then, because it's hallucinating, obviously, it says at the end, if you are looking for more specific information about his background, achievements, or contributions, feel free to ask. So this is the point he's making, that this thing can hallucinate, and if you rely on it entirely for your information, it can send you south, where you shouldn't go. Number two, on bias. And my colleagues know because I've told this story before. I was once called to speak to Chief Justice's Forum in Zimbabwe about technology, and I came across this very interesting story about a robotic judge in California, which had been created to deal with pleas and small claims. But this robot judge had been conditioned to be biased against blacks, so that when a white person comes charged with the same offense as a black person, there is leniency for the white person, and there is a harsher sentence for the black person. So these are the conversations we must continue having as judiciaries as we discuss artificial intelligence. And lastly, I think Kiptines has made a fundamental point about deepfake. Deepfake, when it first came around, like he said, you could quickly pick out that this is, but today, it is so well done that if you were to see the person on this video, you have no doubt it is smoking Wanjala with his left hand. The left hand, the way Wanjala does this, you know, when you can't doubt it's Wanjala, but it's completely fake. So I think it's something that must continue conversing. And now that my son from Zimbabwe has come and he's had a breather, this is Justice Alfred Mavezenge. Dr. Alfred Mavezenge, please, the floor is yours.
Thank you, Justice Leonol. Good morning, my lords and my ladies. So my contribution to this conversation is really trying to answer the question, as legal scholars and as legal professionals, how can we engage with AI? How can we, what sort of theoretical, conceptual tools can we use to understand AI, artificial intelligence? Because it seems to be a very complex phenomenon, or if you want, or a form of technology, which when you think you have understood it, the next day you realize that your knowledge of it is outdated, because it changes quite rapidly, and the law itself is obviously playing a catch-up game. So I grapple with most of the time how AI impacts on transformative constitutionalism, which is really what I want to talk about. So essentially, let's understand, for instance, transformative constitutionalism as this notion of constitutional law which perceives the Constitution as a tool or a bridge or a framework that helps us to transform or to move from point A to point B. At the time that, for instance, the Republic of Kenya adopted the new constitution in 2010, there are certain challenges that the Republic wanted to deal with. And these challenges include inequalities, include restrictions, and so forth. So what then happened is the Constitution then sets a transformative vision or a transformative goal, particularly to transform Kenya to become a society that is based on equality, human dignity, and freedom. So those are sort of the three key values which then underpin that transformative goal. Definitely, this is not necessarily a Kenyan a concept of constitutional law. It is a concept that is quite global in its application. It is erroneously sometimes understood as a South African concept of constitutional law. That is entirely not true. Because long before the South Africans adopted the Constitution in 1996, which embraces transformative constitutionalism, the Indians had already started applying this concept, particularly when they were incorporating the directive principles on health, on shelter, into the right to life in order to enforce the right to health care, even though the Constitution did not expressly provide for or guarantee those rights. That doctrine of transformative constitutionalism, you can also find it in the Constitution of Germany itself. And one example of it is the right to property. When Germany emerged out of the World War II, one of the challenges that they wanted to deal with was the social disparities and the inequalities, particularly between the rich and the poor. The gap was too wide. And so that the need to bridge that gap of inequality informed how the right to property was designed or framed in the Constitution. And so the Germans put a qualifier to the right to property, which states that you have a right to property, but you have an obligation to use your property for common good. And that is the provision that then was which was used to sort of reform the relations between the tenant and the landowner, right? To create, and today I think in Europe, Germany is perceived as one of the countries that has tenant-friendly policies. It comes exactly from there. It's part of the transformative constitutional project. What I think the South Africans can be credited for on transformative constitutionalism is that it became, I think, the first constitution that explicitly embraced this concept. But I think what is key to understand about it, about transformative constitutionalism, is it is a principle that frames a constitutional vision and then perceives the constitution as a tool that then is used to transform society to achieve the goals that are embraced in the constitution. And in the case of Kenya, we are talking about movement or the achievement of a society that is based on human dignity, equality, and freedom. Of these three values, I focus, because of time, I focus more on equality as a core element of transformative constitutionalism. And the question then is, what is the interaction between AI and equality? And that interaction, in a way, influences whether we are going to be able to achieve this constitutional project of transformative constitutionalism or not. And there are three areas that I broadly look at, and I'll be free to share the paper after the presentation, and I don't touch everything. And by the way, I'm only focusing on the negatives for now, because there are positives, but I'm flagging the negatives so that we can think more creatively around how to deal with that. So in the political sphere of equality, one of the negative effects of AI is that it constrains public participation for certain groups of people. A recent study that was carried in the US revealed that there are algorithms that are embedded on social media platforms such as X, formerly Twitter. And those algorithms are designed and trained to give prominence to certain messages while suppressing certain messages. So Justice Lenaola can post something and I can post exactly the same thing. But the traction between the two messages could be different depending on how the algorithms is trained to treat messages from Justice Lenaola and messages from the justice who is not a judge. And the study revealed that political campaign messages, particularly from women who are Muslim in the US, seemed to get less traction compared to the same messages from other demographic groups or persons who belong to other demographic groups. So what it essentially means is that the social media platforms, which are quite essential for purposes of participation, for purposes of public engagements, they are no longer and they are not offering equal opportunities for different demographic groups. Why? And it's carefully designed that way through some of these algorithms. Then let me talk about the economic. In the economic sphere, you would know that most of the time, banks, for instance, or financial institutions, they receive applications for things like mortgage, loans, from a lot of people. And they use AI, or rather algorithms, to sift some of these applications. So before the applications are looked at by human beings, they are first reviewed by AI. And again, these algorithms, a recent study conducted in South Africa demonstrated that these algorithms treat favorably applications that are made by persons from certain races, and they treat the applications from other races are treated less favorably. It's all because of the way the algorithm is designed and trained. The last sphere is the criminal justice system. I think you talked about the example of the robot sort of judge in California. But there's also an application that is used in now I think they've stopped in the US to sort of assess and evaluate whether a convicted person at the stage of sentencing, in the event that you want to give them a suspended sentence or something like that, are they likely to commit similar crime? You are quite familiar with that assessment. Are they likely to commit a similar crime in future, and therefore should we lock them up, or should we suspend the custodial sentence? And this application treats different races differently because of the way the algorithm is designed. So, in conclusion, there are two things that I advocate for. One is that I think we need to... This is an algorithm. I think what we need to do is we need to place more emphasis on transparency in the way AI is being developed, number one, but particularly the way algorithms are trained, because these algorithms are making decisions which affect the rights and legal interests in a fundamental way. But there hasn't been a question that has been asked around how are these algorithms trained? What data are they trained on? Who trains them? So that is one area where we need to focus on. The second and last is access to internet. As you are aware, I think you can't talk of AI without internet. So yes, AI has a potential to improve, quality of life, has a potential to even facilitate the transformative constitutional project, but only if all of us have equal access to internet. I would challenge you to just Google right now the statistics on access to adequate internet in Africa. You find that I think only 22% of people on the continent have access to adequate internet. So what does that mean for access to the opportunities that are offered by AI? In a nutshell, those are the things that I look at in that paper, and I would be happy to share it. And
thank you very much, Justice, who's not a judge. Very interesting statements you've made. And I was just reflecting about an interesting thing that happened about 2 or 3 years ago when JSC was employing court assistants. And I think there were 70,000 applicants. Suppose JSC were to put those applications through some artificial intelligence. And yet, we know that one of the things about employment as a judiciary is regional balance, ethnic balance, women, PWDs. What sort of result would we get as opposed to what we finally got? Because we only employed, I think, 500 out of 70,000 that applied to be court assistants. Interesting times, interesting concepts. Lastly, on my panel, let me now invite Dr. Labuta to make his comments, and then I'll open it up to your questions and comments. Dr. Labuta, please.
Okay. Good morning, everyone. So I just want to ask a question. How many of us have read the terms and conditions of all the applications you use? Laughter is not an answer. So, secondly, the tools that we use at the judiciary. Do you know the terms and conditions, the privacy policy? Interesting. So when I was preparing for this, so we had a meeting with Justice Lenaola. So when I was going to prepare, so I went to the e-filing system and I clicked on the privacy policy, and there was no information. On the e-filing system for the judiciary, I clicked on privacy policy, and so I thought there was a problem, because you remember there was a time the system was, so I tried again and again, and nothing came up. So the question comes in that, what my colleagues have talked about, what makes us determine what technology to use? Is it procurement-based? Because in my advising private and public sector, one of the things is that it's the cheapest. It's what we could find. Or, you know, the PS, the CS, or who has said this is the system we have to use. It's been decided. But then some of the things that we don't ask is, how did we define the problem that we need this system? For example, COVID came and they're like, we need to move online. And remember, that time, whatever platform was available, we moved to it. But we never really had an opportunity to define what was our problem so that we get into this. Secondly, there are never feasibility studies or analysis carried out. So maybe somebody goes and asks, we need a file management system. So the user department comes and says, okay, so which is the cheapest for us? Which one can we use? So you find that the feasibility analysis is really never carried out. Then how do we select an AI model or an AI solution? I think ChatGPT is easy. It's easily accessible for all. So just download and use it. A lot of courts we use Gmail. Why do we use Gmail? Why didn't we use any other? Also have a Gmail account. So another question, why did we choose Gmail? Why not use Outlook? Why not use Supreme Court at judiciary.go.ke? So there's a question, what makes us choose this solution? And where does this solution come from? Who designed it? Because remember, who designs the system? It's like your architect. Your architect knows the nooks and crannies of your house. They know where they used less kokoto, less steel. So they are aware where the weak points are. Then something else that Dr. Justice has talked about is what data do we use to train these AI solutions? Because when you talk about privacy and data protection, there's a judicial officer as an individual, and there's a judicial officer while carrying out their judicial roles. When you're shopping, for example, out there, you're not a judicial officer. Or when you're going to your place of worship, you're not a judicial officer. But when you're in court carrying out your functions, you are a judicial officer. So the question is, what data? Because the question is, the people providing these solutions to the judiciary, do they also use your personal data? So do they know that this judge takes advance every month, this judge has other dependents that they have not disclosed? So what kind of data is used to train? And this is very critical, because somebody can easily profile you. Then how do we train these models? How do we evaluate whether this model is effective? Remember, during COVID, we were trying all platforms online. So this one works, doesn't work, we try another one, until we say, okay, this one is the one that works. Then do we continually refine these solutions? Or we just say, if this doesn't work, let's just get another one and move on. Then how do we monitor? Because one of the questions that perhaps the judiciary should ask, do we monitor and evaluate the effectiveness of these platforms that we use? Then when you're talking about, that thing finally, so you can go to the next slide. So another thing that perhaps we need to talk about is issues of unauthorized access. Is the judiciary able to know whether there has been unauthorized access to our platforms? What is the security level? What kind of passwords do you? So if you have to log into Justice Lenaola's account, is it Lenaola at 123? Or is it, for me I use passwords that are my language, my mother tongue, so I believe hackers can't hack. I try to assume that. So there's the issue of security of these platforms, that who has access? And if somebody got access, is there a record that they got access? And what did they get access to? And why? Are they authorized? Do we categorize this platform? This is for access for judicial officers, this is for clerks, this is for advocates. Then the issue of data misuse. Because I've said, think about yourself as a judicial officer, and also now there's open court records. There's information about you that really shouldn't be public information. When you're having people who handle data on behalf of the judiciary, for example, like insurance companies, etc., are they allowed to use your data to train their AI systems? To what extent do they use that data? I think Justice has also talked about the issue of AI and bias. A lot of AI solutions are trained by data that is not African. There's a big conversation on having African-centric data. So if you buy an AI system, let's say from Bulgaria, from China, it's been trained by that data. So the biases of that society will definitely crop up when you're using these systems. Then there's the issue of trust and public confidence. Has the judiciary explained to the public, why are we using this system? What data are we collecting from the public? Why are we collecting it? What will we use it for? Because it's important, that public confidence, and I think that Dr. Muthuri talked about the issue of KRA wanting to get the IME numbers of our phones. For what purpose? So it says taxation, because data that is available out there could be used for both, I think Justice talked about, for both positive and negative. So how can we avoid the negative? Next slide, please. So, and when we are talking about solutions, the issue of data privacy and data requirements. So when I work with techies, the people who develop this system, they just say, let's collect as much data as possible, we'll find a use for it. Let me give an example. Sometimes you buy either utensils or clothes and you say, I'll find a use for it someday. So let's just buy, and just like data, let's collect as much data as possible. We'll find a use for it. But the problem is that if you don't find a use for it, then that becomes an area of vulnerability. That's how sometimes you go, that article of clothing I bought, where did it disappear to? You bought it 1 year ago, 2 years ago, so you've no idea, somehow it disappeared. Then there is the issue of transparency. And who is accountable? For example, if the judiciary is using systems for decision making, for analyzing data, who becomes accountable? Is it the Chief Justice? Is it the Chief Registrar? Is it the ICT manager? Who is responsible? We need to define, we need to have policies that define if these things are happening, who is responsible? Then for how long do we retain data and we delete data? I think, of course, being a judiciary, you retain data for as long as possible. But then there's the question is, if you delete data, especially in AI systems, what if there is bias? What if you need to audit it later? Of course, the government, there is the documentation and archiving regulations, but you need to think about data within AI systems because this is digital data. Then there is the ethical concerns. I think I'll skip that because the ethical concerns have been discussed. What if I get your data and we say, oh, you know, this is where this justice lives. We can. This is where the children go to school. We saw it in the Gen Z, when people out to wakisalimiwa, they even put a pin location where your father lives, where your spouse goes to work. And the question, where does this data come from? It shows there's a gap in the security of our systems and our data. So if we can know Justice Njoki lives here and we have a pin, her child goes to this school, and this is the photo of the child. This is the contact of her brother, of her sister. It shows that there's a gap in our systems. And this is even made worse with AI because AI is able to churn a lot of data. Then, so when we are talking about data protection and data strategy, are we able to limit the data that we are using to train this system as much as possible? If as a judicial officer, you are using ChatGPT or I think Justice says Nova, do you put personal data or personal information? So it can be Libuta versus Kiptines. So you're saying, you search, how do I decide Libuta versus Kiptines in this commercial contract? So you see that ChatGPT takes that, they know Libuta and Kiptines, there is some commercial dispute. So what kind of information do you input? Then how do you anonymize, pseudomize, encryption? Is data from the judiciary encrypted, especially to people who should not have access? It's security issues to think about. Like I said, is your password Lenaola at 123? Almost. Yes. Then the issues, I talked about the issues of access control, role-based access to this system. Does the judiciary have protocol, ICT, cybersecurity policy? I say, this is who has access to what and at what particular point. And then you have a record of who accesses all this kind of information. Are you transparent? I think I talked about the issue of transparency. Is the judiciary able to explain to the public this tool that you are using? If you have a tool to make decisions about either sentencing or the e-filing, do you have documents or policies that can easily explain to the public, this is why we are using this system, this is the data we are getting from you, this is how we are going to use it. If you have a complaint about how judiciary is handling your data, this is the person you need to speak to, etc. Because you know the judiciary, the judiciary is the only institution that the Office of the Data Protection Commissioner has no oversight on. Everybody else is game for the Data Protection Commissioner. And for the judiciary is well carrying out judicial functions. Though that you can say, what is a judicial function, what is not. So then there's the issue of human oversight. If you are using, I think like Justice talked about, the issue of 70,000 applications and you're using a system to sift them through, do you have somebody who can check whether that's sifting through? You know, in Silicon Valley many years ago, they started that system and they realized it was only shortlisting white males. Because historically, it was only white males who were getting jobs in Silicon Valley. So there's an issue of bias. Then I think I've talked about the issue of explainable AI. Are you able to explain? The next slide, please. Then, so the question is, what assessments are being carried out by the judiciary on these systems that you are using? Assessments that identify what are the loopholes, what are the potential risks, what are the harms, and how is the judiciary going to address those harms and risks. And these audits and compliance checks should be continuous. How you handle data, how your security is, the kind of system that you're using, is it complying with data protection laws, cyber security standards. For example, are we downloading, you know, sometimes we download, if you have a small business and you want to have an ERP to manage your small kiosk, you just tell them, download something online and use it to do our accounts, etc. So the question is it the same in some of the systems that we are using? But privacy impact assessments, data protection impact assessment, security assessments for the tech is what we call penetration test to see how resilient are our systems. Next, please. So, I think that's it. So, so ideally what I'm saying is that we need to have a process where we document and think about the systems, the solutions that we are using. This documentation must be continuous. We must identify the potential harms that have been discussed. We must have very clear strategy on how to address those gaps. We must be very cautious. Do we carry out what we call vendor risk assessment? The vendors providing these systems for the judiciary. Do we vet them and assess, have they also complied with these high standards of security, high standards of data protection compliance? Because if we don't do that, practically, and this is done practically during the development of the solution, during the deployment, and during the use of the so that you don't just wait until somebody has delivered a product. You must check, how did they conceptualize it? How are they deploying it? What data are they using? And how will we audit it from time to time? Thank you.
Wow, thank you very much. I don't know whether you are like me. Every time you listen to these techies, you get utterly terrified.
That's the intention.
I know, especially you. The questions is asked are very hard but essential questions. And for us as a judiciary, I think this conversation must continue because, for example, we've just introduced a new ERP system for the entire judiciary. And of course, there are many questions, a lot of which Dr. Labuta has asked. But again, we've come from very far. During COVID, the Supreme Court used to conference on FaceTime. So now that we are into Teams, we feel like we are a bit more techy than before. But that's a continuation of what we are doing. An interesting question, whether you are a judge when you go shopping. Judge Burgor, you may remember of a judge who went shopping and his card could not run and he sued. And he said, as a judge, when I go shopping, there's a presumption my card must run because I'm not a man of poverty and small means. But these are very interesting questions, very interesting concepts. Reality must hit us that these things are with us. Technology is the future. We can't escape from it. The best we can do is embrace it. We keep saying, as a judiciary, technology is an enabler of justice. What does that mean in real terms? And all these questions are for value. So let me open to you. We should break for tea in a few minutes, but in the meantime, let me ask you to say questions, clarifications. And by the way, the reason why the front bench is empty is because the Chief Justices and those who represent their chief justices have a meeting aside from here. So don't imagine they boycotted the technology session because they are oldies, they're old fogies. They will get notes from us. So any questions, comments? I will not call you Alex today. I will call you Alan Maleche, you are first. Waiko Anyweke, you're second. There's a lady, I can't see who's that? Yeah, right here, there's a lady. And then, yes, Judge, that's number. So 1, 2, 3, 4, 5, and then 6. Then we have to close. Please make them short and succinct. Technology doesn't approve of verbosity.
I think that's a veiled threat, so Judge, I'll remind you this is your second manel in this particular conference. So with that, I hope you give me leeway.
At this time, Joki should carry the blame. Proceed, please.
Thank you. So thank you to the presenters. I want to agree with two things that you said around the digital divide, and I think the conversation around access to justice and technology is one that we should be having in a view to understand how does judiciary use technology to facilitate access to justice and reduce the digital divide. So I agree fully with that. I think the bigger concern we have here, especially for the clients and the cases I bring before the courts on health issues, is about the sensitivity of data and the fact that some of the people who collect the data are not domiciled in the country. So the key concern then is how does one hold them accountable? For instance, Airbnb does not have an office in Kenya, but women have been killed in there, people have had criminal issues happening. Who then do you hold to account in the circumstances? So my key concern is how do we balance the good use of technology to advance access to justice while dealing with the harm that comes with it. And I don't think the judiciary has had difficulty in balancing on the rights to privacy and confidentiality based on the number of cases it has dealt with at the High Court level. Thank you.
Thank you, Alan. By the way, there was a case I handled at the High Court where a prominent Kenyan had sued Google. And the lady went around the world because Google Kenya said, we are not, what you're talking about, we don't know about it. This particular issue is dealt with by Google Ireland. She went to Google Ireland. They said, no, 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 this one is for Google California. She went to California. This is about service. She was trying to serve the correct Google. And by the time I left the High Court, that matter was still lying there because of service. They didn't know which Google to serve. These are serious issues. Waiko?
My question, the first question, I have two very quick questions. One first to Justice Lanaola and the other justice, and then I'll have a question for Kiptness. Adjudication, tech and adjudication. When I think about this in the comparative sense, Kenya has, I think, an opportunity to offer leadership in tech and adjudication in the world. And there are already signs for that. For example, the Huduma number case, whether it's the judicial review on data protection or the main case that Justice Nyamoya read the bench, although that matter has also been sitting at the Court of Appeal for too long. What is Kenya Judiciary doing to be ready to be a leader in tech adjudication, and especially thinking about it in the transnational sense, because tech is where you get into transnational sense. And when Justice Albie Sachs talks about jurisprudence traveling, this is an area Kenya can have its jurisprudence traveling. And I put the same question to Justice because you're operating continentally. What are the leading judiciaries doing? Malawi, South Africa, Kenya, Senegal, Benin. It would be good to know, and even groups like AJJF, how are they preparing judiciaries for that? Second question, slightly to Justice Lanaola, to Kiptness. You know, the Supreme Court likes talking about jurisprudential moments, saying sometimes courts, the other superior courts, think there is a jurisprudential moment where there isn't. I like saying jurisprudential opportunity, because I think there are jurisprudential opportunity that come to Supreme Court and the Supreme Court misses. And one of those is DMS case, the Data Management Systems case, which was a case about privacy and systems, basically surveillance and privacy. And just the question, given where tech is, wasn't it, shouldn't Judiciary have done more, Supreme Court rather, have done more to seize that jurisprudential opportunity, even where there was no jurisdiction? Because it's not unusual for the court to say, we don't have jurisdiction, but we comment on this issue. How does privacy and tech relate? Especially knowing how few cases come. And to keep tightness on the same issue, when should corporates be the one coming to the court to ask questions? How do we honor our right to defend and protect the Constitution when government is pushing us to use our systems for surveillance? And you know that is a very topical issue. Thank you.
Thank you. I think it was a student from Moi, I believe, who was third. Yes.
Good morning. My name is Ongera Lurabina. Just a quick question, but before I ask the question, probably extrapolate what Alex has touched on, and that is on accountability. On various occasions, this would relate more for us who are in the so-called Gen Z generation. There's so many internet platforms that we use, and you realize that when it comes to, because we did this during my research course, and there was an issue on accepting and rejecting cookies, and it was a whole discussion. And we realized that there's some internet services that, when it comes to the question of accepting or rejecting cookies, it's not written in English or Swahili, it's written in some other language, and you are forced to accept without knowing what it is. But that's beside the point. My question would be to Justice. He spoke about access to internet, and my question is, what do you define as adequate access to internet, being that access to internet as a right is more or less of a derivative right? What do you define as adequate internet? And also considering the fact that there are areas, say in reserve, you cannot compare the internet speed with what is within urban areas, so that for people who are living within urban areas, they're able to quickly access information compared to those who are living in reserve areas. Would we say that that is a breach to Article 35?
Thank you. I gather Starlink now is bringing equity because it's more in the villages than in Nairobi. Number 4 was here.
Thank you for the opportunity. This is Jaika Charles from ICJ Kenyan section. My question is directed to Mr. Kiptines and Dr. Laibuta. So I know with the emerging technologies, we've had various cases, especially being handled by the judiciary. For example, the WorldCoin case and some cases on internet issues as well. So if I may link to the question that was presented to us by Dr. Laibuta, why do we use the selected solutions to capture various issues whenever we are selecting on specific mode of relying informations? So based on that, how can legal frameworks balance the benefits of artificial intelligence in legal processes, and especially with the need to protect fundamental human rights, such as privacy and non-discrimination, and that is especially when artificial intelligence systems may inherit biases or lack of transparency. Kindly, if you can link that to discussions on accountability, ethical concerns, and also leveraging on the AI. Thank you.
That requires a whole conference, but I'm sure they can manage it within the minutes we have. Then next.
Thank you, my Lord. Mine was a question in form of, we are using these technologies, are we developing them from within, or are we just acquiring from outside? Because if we are acquiring from outside, then the dangers that, which have been posed to us are quite imminent. But if we are developing them from within, I think we can still have our own solutions. So I was advocating for more of homegrown solutions to our own problems, whether it is data or we are feeding into the algorithms, whatever, then they must emanate from within, because we have our own culture of how we do things, and they should go with that culture also. Thank you.
Thank you very much. This is a question of cost. Do you know how much it costs to bring in this technology from outside? And how cheap is it to develop something inside? Alpha, you can go then, the last one.
Thank you, Judge, and the facilitators. I appreciate the presence of technology, but again, this question goes to Kipnes. Law firms are largely using AI to process pleadings, research, and submissions. The pleadings finally, or these documents finally find themselves in court. And particularly, let me approach research, case law. ChatGPT will take a case law that doesn't relate to the case in hand at all. What would be your advice to the judicial officers and the judges? Thank you.
Thank you. Mr. Ondiek at the back. I believe that's Mr. Ondiek. Oh, it's not. All right, proceed.
Yes, thank you very much. Good morning, everybody. My name is David Arita. I'm a representative from the Electoral Institute and Governance for Africa. So I have two questions, and I'll direct them to Mr. Kiptines and Dr. Laibuta. So they mentioned the element of, Mr. Kiptines particularly mentioned the element of deepfakes and bias when it comes to the utilization of artificial intelligence. So I'll digress the question a bit to the elements of election processes and even judicial, the mandate of judiciary when it comes to elections itself. So what are the implications of artificial intelligence when it comes to the prosecution, or in this case, when it comes to adjudication of cases that have been brought to the judiciary with regards to deepfakes? And also, my second question will be on the issue of algorithmic regulation. This is to Dr. Laibuta. So, do you think there is need for authentication when it comes to the incorporation of artificial intelligence in election resources, in this case when we are facilitating data protection and ultimately enhancing human oversight? Thank you very much.
Thank you very much. You recall Justice Wanjala's question during the election petition about grabbing votes from the iCloud. I guess that's where he's going. Mr. Kiptines, you go first, and then Dr. Laibuta next, then Justice third, and then Mr. Kirinya, any closing remarks? Mr. Kiptines? And please be brief. We are now 7 minutes out of time.
Very well. Thank you, Judge. Some very tough questions there. I'll go to the question by Waikwa Wanyoike on what corporates should do. And really, look, I could see this question coming from a mile away. It's a very tricky question to answer for corporates, because the nature of the relationship a corporate has with its government and the level of, trying to choose my words very carefully here, the level of influence that the government of the day would have over those corporates would to a very large degree determine the ability of that corporate, or even their willingness to seek an audience before the courts for purposes of trying to get the court to enunciate and protect the rights of individuals, which perhaps there's a risk of being trampled on through directions or directives that may have been given to that corporate by the government of the day. And it's a very tricky thing, because I can see very many situations from obviously some of my past experience as to how this would happen. But really, it is difficult. It is really a difficult question, especially if there's a very incestuous relationship between the corporate and the government. I'll leave it at that for now. But I would say that I think there's an opportunity for civil society and individual petitioners really to go before the court and seek the court's adjudication, seek the court's protection where there's a clear and present risk by the government of the day, whether directly or indirectly attempting to infringe on the fundamental rights of individuals. I think that's really as far as I'd go in trying to answer that question, Wakili. The other question that was placed in my direction, I think, had to do from I think Charles Jaika. How can legal frameworks balance the benefits of AI in legal processes and protect fundamental human rights, accountability, ethical concerns? So it's very much an ongoing conversations, because the questions that have been thrown up around process, around fact, verification of fact, around privacy by the use of AI, for me speaks to how far shall the benefit cause us to continue relying on it, but at a pace that allows us to check the risk. And one of the things that was mentioned by Dr. Laibuta, and I said it at the tail end of my conversation, is how to require transparency away from what is called the black box theory, where AI platforms cannot explain or show transparency around how those decisions are arrived at. So getting answers to those questions would lie in technology solutions, applying ethical standards to those technology solutions in order for those answers to come through. So I guess I'm advising some level of caution in how AI is applied. There is no doubt that we're in a much better place today technology-wise, even as a judiciary in Kenya from before 2020. So there are risks you'll take, but at the same time, if there are questions, and I love the questions that Laibuta posed, there are questions that are asked and specifically answered around security, around privacy, around protection of fundamental rights of individuals, then it'll behove the creators of the algorithms to create those answers within those algorithms. That, for me, as I see it, is really the only way to deal with that. And I think there was one final question. There was a question from, I think it was Alfred, I'm not sure I got the name. Law firms using AI to process pleadings and submissions. I mean, this is notorious. This, in my view, is a very lazy way of going about it, and you will forgive me if that sounds arrogant. It's not the intention. When some of us did our pupillage back in the day, obviously, it was coming to the library, pulling down very dusty texts and volumes of law to do research. But technology has made that a lot easier. I think what needs to happen is not using ChatGPT, using it and refining how the experience should be, but undertaking a process of verification. If it creates a fictitious case for you because you've asked a question on a certain principle of law, and ChatGPT, using its 2+ trillion data parameters, will give you a fictitious case. Well, it behoves you, before you present those pleadings or indeed submissions filed in court, to ensure that in fact is a case that exists. It can simplify the process by identifying the cases that would be supportive of one's arguments. But verification, I think, is absolutely essential. You cannot have a blind reliance on it. I think for me that's just simply how it goes. I mean, it's even more tragic if a judge would rely on ChatGPT more than that of counsel before the bar, because then there's a risk that the decision that is taken will be based on erroneous data or biased data. And finally, Bwana Arita, the implications of deepfakes to AI in the adjudication of cases, you know what, it's very scary. It's extremely scary, as Leonard Judge said, but I think for me as a technophile, the answers lie in technology, but asking the right questions. If I don't ask the right questions of the tech, then it lead me down a very scary path, and there's nothing I can do to get out of that unless I seek the right answer. So verification is still absolutely essential, requiring transparency, requiring a move away from the opaqueness, using it as assistive as opposed to relying blindly on it. I made a comment by saying AI is not the be-all, end-all. It's not the answer to all the questions. It is merely assistive. Thank you.
Thank you. I think there's something Justice Leonora said. I think there's need perhaps, and I saw Honorable Arika was around, there's need for all judicial officers perhaps to go through a training and understanding of these systems. What is AI? And it's not just AI, all kinds of emerging technology. These security issues we are discussing, I think is something that will be vital, so that if you are faced with a disease, I think somebody mentioned the DMS decision. What is DMS? What does this technology do? What are the pros and the cons, and how can you balance the rights? Secondly, just to answer these questions together, I think the judiciary perhaps needs to consider, is there, for example, an AI policy? Is there a policy or a guidelines for judicial officers to use ChatGPT or whatever GPT is out there? I think it's something to really consider. Does the judiciary have, for example, an internal cybersecurity policy? And what does that, and do members, both the judicial officers and the staff of judiciary, understand the ramifications of the cybersecurity policy, physical security policy, privacy notices? Is there a privacy policy? What kind of data can be shared? What cannot be shared? What is the obligation of a judicial officer, a court clerk, a researcher, etc.? So these policies and guidelines within judicial, because if we wait for the government, for example, to do like the EU to come up with an artificial intelligence act, it will take many years. But I think it's high time the judiciary thought, what kind of policies, strategies, standard of operating procedures can the judiciary put in place on these issues that we are discussing? Then something else that I think also where there are court case, for example, somebody asked the issue of holding international digital platforms accountable. There's a Court of Appeal decision where it said Meta, for example, is bound by the laws of Kenya. So long as you're operating in Kenya, you're bound. Actually, when you look at the Data Protection Act, Section 4, says so long as you are processing data of people within Kenya, you are bound by the Data Protection Act. And so I think the judiciary has gone far and said that so long as, even if it's an international corporation, not having an office in Kenya, but if you're processing personal data of people within Kenya, then you have to comply with the Kenyan constitution. In terms of the WorldCoin, there was an investigation by the Data Protection Commissioner, by the Communication Authority, and by Parliament, and there's a report by Parliament on how this needs to be carried out. So one other thing that I will propose is that the judiciary needs to have conversations with these regulators about how to improve processes system. There's that question on accepting and rejecting cookies. That's why I say a lot of us don't read. I asked who has read terms and conditions. Actually, I don't read them. I read them when I was doing my doctoral studies, but before and after them, I don't read them because I need to use a tool. But you see, if you are doing, that is just for social media, but if you are using tools critical for your work, you really need to understand what are the terms and conditions. It's not like you're getting into Facebook or X or Instagram, but if it's systems you're using for your critical work, really, you need to know the terms and conditions. Then there's a question on homegrown solutions. Good idea, but they're expensive. Let me give you an example. If you're going to get a solution, for example, from AWS, Amazon Web Services, it's cheap. You can get it so cheap, but if you tell somebody to develop it, so if you tell a Kenyan developer to develop it, they don't have the infrastructure. It will be so costly. So those are some of the pros and cons. Amazon Web Services, Microsoft Azure will give you a solution off the shelf and then customized for you, very cheap. But then there's that big question. I think Justice Deo from Tanzania asked them, It's a big question, homegrown solution, but there's the issue of scalability and whether these homegrown solutions do have the infrastructure. Just as a parting shot, there was one question. In Africa, do we have the right number of data centers to allow these homegrown solutions?
Thank you. 3 questions and quickly. My brother Waiko asked a question, what can we do, what is AJJF doing? So Africa Judges and Jurists Forum, an organization to which myself, Judge Dingake and Justice Lenaola belong to, what we do is we are also trying to develop consciousness and capacity around these issues so that first and foremost, as members of the legal profession, we ask the right questions. I earlier spoke about transparency, and let me break it a little bit down to answer and illustrate, what can be done in answering to Waikwa's question. Every country across the globe has policies on education. You can't just open a school there and start teaching law. You have to comply with certain regulations, including regulations on the curriculum that you use. You can't just open a medical school and start training doctors, right? Now, if these algorithms are essentially being trained to do what human beings do, or perform functions which are supposed to be performed by human beings, and human beings, when they train in order to be certified, to be competent to perform those functions, if human beings are subjected to training which is regulated, why are we not regulating training for algorithms? They should be regulated, isn't it? The same regime that you use to regulate training for human beings should also be adapted to regulate training for algorithms. So what it means is we need regulatory policies in place. If governments don't have regulatory policies in place, it means they are in breach of a number of violations. And it is the role of lawyers, civil society, and the public to hold the state accountable. But judges must first and foremost understand what these algorithms are. Right. There was a question about what is adequate internet. Very good question, which also requires a conference. Right. That question is a question that needs to be answered, but there is no answer for it right now. Why? Because our policymakers are sleeping on duty. You see, access to internet is actually a human right, because without access to internet, you cannot exercise freedom of expression, you cannot exercise freedom of information, you cannot exercise a whole range of socio-economic rights. Right. So now, if we do not have a policy which sets a minimum content on what adequate internet is, then it means that the policymakers are abdicating on their duty to actually develop such a policy, and they need to be held accountable. So those are the questions that civil society, that lawyers need to bring to the courts, but judges need to first understand what is the connection between internet and all these human rights, and why is it important to define adequate and how do you do that? Of course, you do that, I think, by looking at what the minimum requirements for freedom of expression, access to information are. But that question needs to be answered. The third one is on homegrown solution. I have a slightly different answer to you, my brother, on that one. I think we need to develop our own technologies as Africans. Yes, it's expensive, but we have money. Africa is one of the richest continents. But we steal the money, and we externalize the money to Europe. In fact, most of the people who are at the forefront of developing these technological innovations are Africans who are working in the US. Right? But it's because we are not able to utilize them as a continent. So what we need to do is we need to rethink. If we don't do that, then I think we are heading to another form of colonialism. I don't mean to scare you, but that is exactly what is happening. Because we are going to reach a point where we will not be making any decisions as a continent. Those decisions will be made through algorithms somewhere, right? And you made a point, and I promise the last point. You made a point about data that these technologies, these algorithms are trained on data that is outside of Africa. That is correct. That is correct. I just want to add another dimension to that. These tech companies have also harvested data from Africa. They have the data. But then the problem is those algorithms don't understand that data, because that data is different from the data that is in Europe. For instance, hate speech. Most of these algorithms are trained to pick hate speech on X or on Facebook and quickly delete it, right? Or there is this community notes thing on X, which then is supposed to clarify that this post or this publication is not true. But then, how much hate speech is on X or on Twitter that is expressed in local language? There is a lot of hate speech in Shona, a lot of hate speech in Kiswahili. But those algorithms don't understand those languages. They understand English, they understand French, they understand Spanish, and all these things. This is why when you buy this phone, the guide or the manual is written in several languages, but none of those languages are from Africa. That is the same thing also with algorithms and so forth. So I am saying we need to take initiatives as a continent to enter this debate, but not as consumers of technology, but also as producers of technology. No matter how hard and expensive it is, this is something that our policymakers need to take very seriously.
Mine is very short. There are no questions directed at me. But I would say it would be very difficult to regulate algorithms. Technology and law class 101 in university, there's a principle called technology neutrality. That means you don't legislate on specific technologies because they change. They become obsolete even as soon as you've enacted them. Now, a lot of what Kipton has explained as AI, I would say is machine learning. It's brute force. It's forcing a computer to understand that this image is a jaguar, the cat, and this image is jaguar, the car. And you'd be shocked. A lot of that training has been happening here in Nairobi, Mombasa Road. If you read the WorldCoin report that was in Parliament, there are 4 million crypto traders in this country. We are very digitally advanced. We are the ones developing the technology and developing the algorithms. I would also say that from the legal side, let's play to our strengths. Let me give the good example that was given. You're recruiting 70,000, you're analyzing 70,000 applications and you need only 500. You know your legal limits. The law is very clear that you cannot do algorithmic profiling or algorithmic decision making. What does that mean? It basically means that you cannot use an algorithm or a computer to make a decision that has a legal effect on someone, whether it's issuing a loan, whether it's giving a job, whether it's using whatever. But then we can bring it a notch below, because there's other parameters that you need to be looking at: age, gender, regional balance, etc. You can use AI for that, and you can justify it. You can even use it for technical qualification. You can say maybe 35,000 of these applications don't qualify. Then you give someone to actually confirm that that is true, and the remainder is actually true. So that is what, moving from what Kipton has talked about, the black box theory, we are moving to explainable AI. On 1st of August 2024, the European AI Act came into force. So now we're moving, and you remember they're the ones who gave us the GDPR a few years back, and the Data Protection Directive. They help us to define the law in this area. Simply put, law is, right now, the arms race in Silicon Valley is to make sure that the algorithms can satisfy the legal service standard, service level agreement. Basically, unlike other fields, let's say medicine, engineering, a as long as we can figure out, as long as the algorithm can show that there's cancer cells here, and it's as good as the radiologist, no one is asking for an explanation. And the same thing with banking. As long as the algorithm can show that this is an outlier transaction on the credit card, it's probably fraud, no one cares. It's shown it and it's proved it using the brute force machine learning. But what I was trying to explain with my presentation earlier is that in law, that is not acceptable. So the arms race right now in Silicon Valley, by end of year, they were saying that they will automate call centers, etc., because it's just very straightforward. But in law, you need the logic. You need to explain your logic, what we call the ratio, right? And that's where the arms race in AI is right now. We have to break that black box, and that's why I was saying we need to use different types of algorithms, and you can't regulate that because it will also change. But we're coming to the point where that is really where we're now working, and I'm sure very soon we'll be there. But as Captain has said as well, there's other low-lying levels of application that the judiciary can already start using AI for. Thank you.
Thank you very Thank you very much. I think you must agree with me that this has been a fantastic panel, but let me answer two questions from Mr. Waiko Anyweke. What are we doing as a judiciary in terms of adjudication and technology? Dr. Smoky Wanjala is here, Lilian Rika is here from KJA. We signed an agreement, an MOU with the mobile technology providers to have trainings on mobile technology first, and then, like my colleagues have said, we need more training on all these issues that are coming to court, because unless judges are themselves aware of the issues that are being addressed on the panel, we cannot make good decisions. So that is our way of trying to say, let's get ahead of the game. Someone said today, law is catching up with technology, but we as judges cannot afford to wait to catch up with technology. We must, at the very least, be together with technology. Seizing differential opportunity or moments. The case is before the East African Court of Justice, so I wouldn't go too much into it, but yes, I think my colleagues here can agree with me when I say we try within our means to seize the moment, and Judge Joki, her second name is Jurisprudential moment, because she always says, this is that moment. So I think don't assume that we are just sitting there without doing it. Lastly, on homegrown solutions, myself and a few others have gone round, Israel, India, we were in Brazil with the court. They are all telling us, find a way of creating homegrown solutions. They're not telling us how, they're telling us what, but that conversation must continue, and so I agree with Justice. Let's find a way. I sit on the board of a body called Laws.Africa, and we're also having that conversation. How do we ensure that laws reach Africans? How do we have homegrown solutions? Just last week, I sat with a young lady from Stanford University who's developing, using AI, a case search solution for Rwanda, and we want to bring it here also, where the kind of thing we do with Law Africa is advanced using AI more than what we have today. So these are conversations we are continuing to have, and I am sure we'll get solutions too. And lastly, in terms of policies, Judge Sichale is here. Judge Sichale, we brought to the JSC a number of policies for approval because that is the procedure, including cybersecurity policy, the ERP policy, which we are discussing. So we have a number of policies, and we are, in my ICMS committee, we are now discussing an AI policy for Kenya. And so we are trying to get ahead, including on policies. Let me now close by having you please join me in thanking our panel. It's been a wonderful panel. And I apologize if you have a headache like myself, because these things are very heavy. But it was useful that we have it. And of course, please clap for your moderator. It has been a very good session. Thank you very much.
Thank you so much, Justice Lenaola, and the panelists for taking us through that. Let's continue clapping for them as they come down. Yes, and we'll now take our tea break. Yes, as we take the photograph, we will have a tea break. We are 30 minutes behind schedule. I'll request that we take our tea in 15 minutes so that by 11:20, we'll be back so that we can catch up on time. Time for break. Thank you.
Thank you, guys. Wonderful. You're very good. I thought we were starting at 10. I saw you walking with a cup of coffee. Audio yako. Ina malpa volume hapo kweli? Haina malpa volume. Kwa mwisho. Tunameka gain mpaka huko.
Check on two.
If haikuwa juu hivi na iko juu tena ingine. Ebonge. Copy ingine.
Check on two. Hello.
Pale tuko na panelists wanne.
Sahi ni wanne. Moja itakuwa itasaidia.
1 2 Check two. Check 1 2 2.
So hii itasaidia ile
2 2 1 2 1 2 1 2. Two. Check 2 2. 1 2 1 2. Check 2 1 2 2. Testing mic 1 2 2. 1 2 1 2 2 2. DJ. 1 2 1 2.
Iko sawa. Wakubwa mko hapa kidogo, niwachie bagi yangu dakika 2. Nachukua something kwa tag pale. Sawa, uko hapa nikuachie bagi yangu for a minute. Sawa, sawa.
Niko umeelewa eh? Inaona iko sawa.
1 2.
Ama niende pale wazo.
1 2. Testing mic 1 2. 1 2 2 2 2 1 2. One, two. Testing mic 1 2. 1 2 1 2. Yes, we're good. We are good to go. 1 2. Test mic 1 2. 1 2.
Good morning. A small announcement, please. For the law schools that participated in the moot court, the representatives who are here, the students and the coaches, kindly let us meet in the tent briefly. I urge you to come.
And that's something that can weigh down on human beings.
The time for hearing is so short, the evidence voluminous, and then there's the further submissions. And finally, for the judges to retreat, sometimes they retreat only for 2 days. You should have at least 60 days. Minimum, in my view, 45 days.
The Supreme Court has moved in, and it is our priority to build a Supreme Court. We are sitting in a new building, the museum, where we have no space. So we have plans to build the Supreme Court of Kenya.
The court strives for excellence in its case management, from scheduling hearings, settling timelines, managing case documents, facilitating communication between parties, and ensuring that cases move through the system in a timely manner. The court has also harnessed technology to improve on its efficiency and effectiveness.
The Supreme Court is basically a virtual court. We do not have physical hearings, so we have a virtual court for all the hearings, unless there is any need to have a physical court. And I stated that the physical court ordinarily is during the presidential election petition. The rest of the matters, and virtually anybody can log in from any part of this country. We have a virtual customer care desk. You do not have to come to Nairobi or any of the sub-registries to get information about your matter. You can virtually be assisted by the staff from the registry. The e-filing, you do not have to come to Nairobi or to any of the registries to do your filings. You can virtually file them through the e-filing or the CTS system that is in operation within the courts. To ensure that cases once filed, the law therefore my responsibility is to ensure that the cases are settled. If not within the 90 days, and thank God we have settled many long before the 90 days, then it must not go beyond 90 days by too long. You know, I tell people who are from outside of our country about the extent to which the judiciary has embraced technology. I don't believe it until they become consumers of justice, and they're like, this doesn't even happen where we come from, you know, and that's supposed to be the result. So I can tell you the entire judiciary technologically is being so very well.
Yesterday I saw a post, a forum at which I believe Justice Mohammed Ibrahim will be speaking. I think we would like to see more of those. I think we would like to see more visibility of judges of the Supreme Court within an academic setting in which they speak about matters of public interest. The judiciary badly requires financial stimulus. So it provided in Article 173 for a judiciary fund to be established to enable the judiciary to run its affairs.
Everyone around us, tell us what we've done right and what we've done wrong and what we can do better.
The judiciary is one of the three arms of government, not the third arm. There is need for the other two arms to consider the judiciary as part of the government. We have not brought on board the general public. Courts will play their role, but theirs will be limited. To what extent can a Kenyan, for example, feel that they are part and parcel of what is happening?
And we celebrate this 12 years of this court. Give us feedback. We shall introspect. And we can only make this court better and make our judiciary better for the sake of the great people of the Republic of Kenya. Kenyans have been very supportive. As one of the levels of court in the judiciary, it has strengthened the independence of the judiciary. So Kenyans should know that the judiciary is there for them, the Supreme Court is there for them. Our doors are open, and with God's blessing and the support of all Kenyans, we would like to continue discharging our constitutional obligation so that Kenyans enjoy their basic human rights and the rule of law.
It is that one court where you know you have one option, which is to get it right, to do it right, to stabilize the country. There is a lot of hope of even getting Kenyans embrace all these principles that are enunciated in the Constitution. The principles of good governance, the principles of respect for one another, the principles of non-discrimination.
1 2. Wacha nijaribu kuweka on ikiwa kwa desk. One, two, 1 2, 1 2, 1 2, 1 2 2, 2 2 2. One, two. 1 2. 1 2 2 2 2 1 2.
One institution stands tall, the Supreme Court of Kenya. For 12 years as an arbiter of justice,
1 2 1 2. 1 2. Testing mic 1 2. 2 2 2 2. 1 2. 1 2. 1 2 2 2 2. 1 2.
Ongeza kidogo.
1 2. Sawa. 1 2.
The Supreme Court was established after the promulgation of the Constitution of Kenya 2010.
1 2. So.
An apex court that could settle with finality certain complex matters like inexpediency, like the presidential election dispute. The Supreme Court has also settled many issues involving the application and interpretation of the Constitution, which is an original mandate given to the Supreme Court.
There were so many challenges in terms of democratic governance, which started, of course, with the Independence Constitution, the 1964 Constitution, which then was amended, and with the Constitution amendment starting from 1991, the introduction of multi-party. There were amendments in 1997 to open the space for electoral democracy. A failed referendum in 2005 when Kenyans said no to a new constitution, to the elections of 2007. And as a result of that, they created what they call the Agenda 4. And one of the agendas was to create a new constitutional dispensation.
The entry of the Constitution 2010 of Kenya came with a fundamental shift in the constitutional architecture of the country. The Supreme Court of Kenya, as the apex court, was established to inject new judicial philosophy and develop indigenous jurisprudence that aligns with the new constitutional provisions.
I was lucky to have been appointed a member of the Constitutional Review Commission of Kenya. Kenyans were particularly concerned about the judiciary at the time, that the Court of Appeal as the final court at the time was not sufficiently capacitated to handle matters of national importance with finality to the satisfaction of Kenyans. They also said they want a court which would be above the Court of Appeal at the time, a court that would then have the confidence of Kenyans that when we've exhausted the legal mechanism, we receive justice at the highest level, which would be the Supreme Court. So that was the history, and the reason why the Supreme Court was created.
The Constitution under Article 163(1) established the Supreme Court as the apex court in Kenya with the following mandate. A. Exclusive and original jurisdiction. Tribunals formed for their removal from office. D. Render advisory opinions. And E. Determine the validity of declarations of a state of emergency.
Let us settle down to begin our session. And this is our last session before the official closing. If we could save some minutes. So this is a session on the role of development partners in supporting the realization of the constitutional social justice promise. It will be chaired by Honorable Justice Mohammed Ibrahim. Welcome, Judge. And the panelists are Anne Gitonga. Please come forward, Anne, Head of Policy and Partnerships in IJM. We have Ms. Julie Matheka from ICJ, the Programs Manager. And we have Carol Kariuki, the CEO, KEPSA. And just to ensure that it is not all female, we have Felix Othiambo from Elgia joining the panelists. Yes, protocol, can I have a seat? Sorry about the mix-up. Welcome, panelists. You can kindly take our seats. Thank you, Judge. You're most welcome. You can start off. It is 11:35. So we will finish at 12:35, exactly 1 hour. Welcome, Judge.
Good morning. Good morning, all present. Honorable judges, as we are aware, our Chief Justices are in a closed session in another forum. But they'll be joining us soon. Good morning, honorable judges. All protocols observed. There are so many of us here, and I will wish to ride on the protocols which were set out this morning. We have a session here, the last one actually, and I'm honored to chair that session. For purposes of introductions, my name is Justice Mohammed Ibrahim. I'm a judge of the Supreme Court of Kenya. I'm one of the judges currently constituted in that court, and I'm very privileged and honored to welcome you to this session. And I'm so excited that we have had this amazing week, and that now we are winding up with this session. the topic that has been scheduled for us is the role of development partners in supporting the realization of constitutional social justice. This topic has been carefully picked by the organizers for very good reasons, because one of the agenda of the blueprint under which we are operating at the moment, established by the Honorable CJ, Chief Justice, is an issue of constitutional social justice. I have with me here are a very eminent a panel of experts, scholars, and professionals in their specialties. We'll be introducing them, and to save time, I'll be referring you to the program whereby the biodata and information about the panelists are all there for all of them, except Madam Julie Matheka from ICJ, but I will briefly introduce her. But now, as an introduction, I would like to introduce the members of the panel. We have Mrs. Anne Gitonga. Anne Gitonga heads the Policy and Partnerships Department at the International Justice Mission, IJM. And please, I request to save time. I don't have to go from her bio, which is quite rather detailed, so we're saving on time. But she's an advocate of the High Court, and she's supported by a Bachelor of Law degree and a Master of Law degrees from the University of Nairobi. And she has worked with the ICJ before, and has experience in international development and democratic governance, focusing on projects that enhance rule of law and access to justice. Welcome, Madam Anne Gitonga. Karibu sana. We have Mr. Felix Uwor. Mr. Felix Uwor is the Executive Director of the Electoral Law and Governance Institute for Africa, Algeria. And please, again, I request you to refer to his bio. And he has been providing technical support to bodies like AU, East African Community, and SADC, and also to the Judicial Committee on Judicial Elections, of which in Kenya, for the Kenya Judiciary, the JCE, of which I chair. So he's a very close person that we work with. We also have Madam Carol Kariuki, present. Welcome, Mr. Uwor. We also have Mr. Carol Kariuki. She's the CEO of KEPSA and has been instrumental in transforming the organization and a major force in Kenya's economic agenda, focusing on private sector development and public-private partnerships. Karibu, Madam Kariuki. And lastly, we have Madam Julie Matheka. Julie Matheka Waiwa is a program manager at the Kenya section of the ICJ, International Commission of Jurists. She has previously worked with the National Council on Administration of Justice and the Business Committee. She has worked with the Commercial and Tax Division of Kenya's High Court and with KMJ. She's an advocate of the High Court and a holder of master's degree. And she's here with us as a member of this panel. Welcome, Julie. Thank you very much. As you are aware, since the establishment of the Supreme Court, since the promulgation of the Constitution, Kenya's judiciary has developed several blueprints. After the Supreme Court was established in 2011, that was when it was fully operational. Since it was established and operational, we have had 4 blueprints by the respective Chief Justices to reform and strengthen the institution through access to justice and align its operations with the 2010 Constitution. Coming first, leading the way, was Professor Willy Mutunga between 2012 and 2016. He called his blueprint JTF, Judiciary Transformation Framework. Followed by Justice Maraga, the next CJ, he launched his blueprint and referred to it as SJT, Sustaining Judiciary Transformation, aimed to sustain and deepen the transformation efforts through reforms to make justice more efficient. And lastly, and currently, we have STARJ, the blueprint that is currently in operation, Social Transformation Through Access to Justice. I think if you note those words, it rings a bell with the topic of the subject this morning. Social Transformation Through Access to Justice, STARJ, under Chief Justice Martha Koome, aimed at ensuring that judicial transformation is sustained and that justice reaches even the most marginalized populations. So that's why we have picked this topic deliberately picked this topic on the role of development partners in realization of constitutional social justice, because the development partners that we have and hope to continue having, they support us from time to time, and many of them quite continuously, have been very useful in our discharging our functions as a judiciary. The judiciary and the JSC, Judicial Service Commission, as public bodies, are funded through public funds. Every year, the judiciary prepares its budgetary needs and presents them to Parliament. Parliament does not always approve the full budget, and that leaves the judiciary without sufficient resources to fund its budgetary needs. This is where the development partners come in. Each country has its own foreign policy, and through bilateral relations, these countries support developing nations in various programs focused on access to justice, poverty reduction, gender equality, and economic empowerment. The needs of the judiciary align with areas of support, in particular, the rule of law, constitutionalism, and social justice. Development partners play a critical role by providing financial, technical, and strategic support to help nations achieve equity, inclusivity, and human rights goals enshrined in their constitutions. By working closely together with local governments, civil society, and community organizations, development partners help to bridge resource gaps and build institutional capacity and promote accountability mechanisms that align with constitutional mandates. This collaborative effort not only accelerates the realization of social justice objectives, but also fosters a more just and equitable society for all. That's why we thought it was important in this program to recognize the role of the development partners who have assisted and the judiciary in achieving its obligations and mandate through such filling these gaps that we have referred to. So experts in this area of partnerships with development matters, representatives of various institutions or bodies that engage with with states, governments in development collaboration are here, and they represent the major ones with whom we engage. And please join me in welcoming today's panel. We have chosen some themes which will guide us in our discussion, and they revolve around 3 areas or questions which we would like to present to the panelists for them to maybe partly or wholly use those guidelines to assist us to engage and discuss on areas that where by engaging and discussing we will understand the role of the development partners. One of the questions is how do development partners balance their support for social justice initiatives with the sovereignty and self-determination of the countries they work with, ensuring local ownership of constitutional justice reforms? As you are aware, this is a very controversial issue. Many times governments question how these institutions that obtain support from development partners engage with the development partners who quite many are foreign-based or are from abroad. And even there are questions about the issue of whether we are patriots by engaging with them, whether they have other interests and so on, which may undermine any national interest and so on. But I leave that to the members to touch on, to discuss that. Number 2, how can development partners effectively collaborate with governments and civil society to promote and safeguard constitutional social justice? And lastly, do you have any successful approaches, panelists, or initiatives where development partners have significantly advanced constitutional social justice, and how can this be replicated or scaled in other contexts? So, having been given that time of just under an hour, and having taken some minutes, I will give our members maybe about 6-7 minutes each, if possible, to see and give them freedom to discuss any aspects of those topics. And I'm sure they have some of their understanding and aspects that they wish to share with us. And I will start now. It's my honor to invite Madam Gitonga, IJM. Thank you. Karibu.
Thank you, Judge. Thank you, Judge, for that question. And allow me to write on the protocols that have already been established. And you correctly say that this is often controversial, the question of development partners supporting critical institutions such as the judiciary, and how do we retain and respect sovereignty of countries. So in developing projects, development partners will often carry out research, what we often call gap analysis, situation analysis. We sometimes call it needs assessment to establish the needs of a host country. So a lot of background work goes on in establishing what a host country would be interested in. And while doing this, development partners respect and understand and recognize that
countries have control over their reforms, over their laws, and also have control and can make decisions. So development partners will carry out this research to inform their own programming and strategic areas of focus. But beyond that, when they come into the country, the host country, development partners will often come in on invitation of the host country. I'll give an example of this conference, and I remember the Supreme Court judges invited us somewhere, and they in Nairobi, and gave us the idea that Supreme Court will be commemorating 12 years. And it was up, they did not force us, it was up to us to see how this aligns to the strategic areas that development partners have already identified. So we respected that and respect that this has been driven by the Supreme Court, even though there has been a level of support from development partners. To add on to that is to say that development partners will always ride on existing frameworks. And the judge has correctly stated about the JTF, the SJT, and now the STARG framework. The STARG framework, the Constitution of Kenya, they are all very well loaded with aspects of social justice, constitutionalism, promotion of rule of law, and human rights. These themes resonate very well with what development partners are already doing. And therefore, we come on to a program that already exists. We come on to a program that has already been established, and mainly only to support. There has been a question, there has been a belief that development partners will only come in to provide financial aid. That's not the case. In most cases, development partners will also come in and bring technical expertise. And technical expertise can even be sourced jointly with the host country. And our experience working with the Supreme Court has been very productive, because we have had consultation where they asked us, they told us would they prefer perhaps to offer technical expertise. And therefore we respect that the decision and the choices have to be made by the host country. I'll add on to the fact that beyond technical expertise and financial aid, development partners will also bring in cases before courts. In the Supreme Court petition number 11, FIDA Kenya, which is a civil society organization, was one of the petitioners, and they canvassed the question of equality under Article 45. So we still have that open dialogue and strengthening of the institution through bringing on cases, and sometimes even through bringing in technical expertise where required. I'll add on to say that development partners through civil society organizations and even community organizations have been able to interface with the public. There are certain questions that the public will often ask about the court that the Supreme Court judges may not reach those members of the public. But with support from development partners, civil society has been able to engage communities. And I'll just mention that this week I'm in the process of helping support a program that is targeting CUCs in Makadara law courts, where the public will engage with the justice actors and they'll be able to ask questions. Because some of the times the public will go to social media and make a lot of complaints because they don't understand the system. But through collaboration with civil society organizations, we are able to demystify some of these questions and reach the public faster. The approach I would say that has been useful in my experience has been through co-creation and collaboration, where we design projects jointly. And I'll give an example of my experience in my previous employer, International Development Law, IDLO, who has successfully managed to carry out research with the Judiciary of Kenya and supported ease of doing business as well as commercial justice, which research partly informed or accelerated the process of digitization. So it's a very fruitful engagement. It is not often a case of, we have to balance the sovereignty of countries, but it's really a collaborative approach. Thank you.
Thank you very much, Madam Anne Gitonga. Thank you for, you have said it very succinctly and in a very brief way, but I think it's come out very clearly. Now, so that I would kindly request our panelists if we could kindly follow the way we are sitting, that the next panelist to speak would be Madam Julie Matheka, so that at least I don't get confused. So that and then we end up with a gentleman at the end. Honorable Julie Matheka, karibu.
Thank you very much, Judge, and I pray that the blessing you have bestowed upon me to be a honorable person one day comes to fruition. All protocols observed. I will ride on the protocols established earlier, and thank you for the opportunity to be part of this panel. I will pick up from where my colleague has left off because we're in a similar sector. As ICJ Kenya, we are a membership organization that is based in Kenya that works on the question of rule of law, democracy, human rights. But we also have linkages with the ICJ Kenya in Geneva when it comes to similar issues. So one thing that we have found is very effective for us is the question of sharing of information, networking, and partnership. As ICJ Kenya, we believe that solutions are not only found within the borders of our country, but can also be found from experts, from regional bodies, and from other persons who have experienced similar issues, and therefore can lead to the development, creation, and amplification of an idea. So for us, we look at spaces such as this for the opportunity for people to dialogue and understand one another, and also share expertise. So one strategy for ICJ that has really worked is the question of networking and partnership building, because we believe that in collaborative efforts we can actually drive change and reform. For us as ICJ Kenya, when we come into the question of how we work as a development partner through civil society, because we do both sides, we look at the strategy that is in place and how we can fit into the strategy and how our strategy aligns with the entity that we are supporting. We are privileged to not only support the judiciary, but also to work with other entities within the justice space, be it the Independent Election Boundaries Commission. We do work with Parliament, and we do work with the devolved counties. So we do work with various actors. And for us, it's a question of what is the synergy and what is the sinkage. So when we look at the idea, for example, on the judiciary, for ICJ Kenya, being 65 years old, we have worked with the judiciary in various capacities. We have worked with the judiciary on the question of capacity building. A new issue has emerged. How do we engage the judiciary to ensure that the international developments that are there can translate in actually our judiciary applying those similar principles? But there's also the question around, because we do not have that particular principle that we are using, how then can we engage in research? How do we ensure that we actually create bodies of work? And I'm very privileged and thankful to the Kenyan judiciary because of allowing us to collaborate quite fruitfully on the question of research by the leadership of the Director General KJ and also the Committee on Elections, because as ICJ for the last 5 years we have been developing the compendia on election management. And for us in that particular compendia, we have been looking at how do we ensure that emerging issues are captured? How do we ensure that changes in electoral law are therefore captured? So for us, we have been developing content. And not only do we then do it on issues that we are well versed in, for example, the election space, we then traverse into other issues. For example, the discussed issue of economic and social cultural rights. I think from this particular Supreme Court at 12, we can appreciate that this is an area of law that is yet to fully be developed. So for ICJ Kenya, we looked at the question of right to health and how we can ensure that we have and capture emerging jurisprudence on the right to health. This will not only work because we are a lawyer-based institution, advocate-based institution, to enhance our capacity, but will enhance the judges' capacity when they're dealing with certain nuanced issues that will come before them. So the area of capacity building is important for us. Another issue that we have strategically used is the issue of litigation. As ICJ Kenya, we have funded others to do litigation because of our capacity as a development partner and appreciating how important litigation is in changing the law, but we have also become litigants in many matters. One matter that I want to talk about is the question of being amicus curiae in the Muruwatetu decision. I think for ICJ Kenya as an abolitionist institution, we are very particular about the fact that we want to abolish the death penalty. But we are not there yet. But how can we chip away at it until we get there? The question of mandatory minimum conversation was important for ICJ Kenya, and that is why we engaged in the conversation on the abolition of the death penalty through litigation on the issue of mandatory minimums on Muruwatetu. As a development partner, we also step into the gap that is created sometimes. We appreciate that judicial institutions, for them to function efficiently, need funding. And I'm glad that judiciary funding has become a conversation that this particular administration in their manifesto took on. But it isn't as easy as it can be potentially put to be. The advocacy around judiciary funding began immediately the Constitution was in place. And right now is when you're benefiting from the judiciary fund. It has been operationalized to a large extent, but it has not yet been resourced adequately. So it has been a drive by various development partners, various civil society, appreciating the various manifestos, the various strategic plans of the 3 Chief Justices on how to push the judiciary forward for us to then speak out and advocate for the creation of the judiciary fund. So those are the strategies that we have used. In regards to the question of sovereignty, luckily I'm not in a position to be questioned around whether or not as an international we are coming on to channel our ideas, but we have gotten the question around the people who are funding you, are they perpetuating a particular narrative that you are then using to tilt the court in a particular way? I think for us we look at the question of human rights, and that is our guiding philosophy. Is it human rights? Is it governance? Is it democracy? And once we establish that indeed this has an impact on the rights of every single person and we want them to live in dignity, we therefore take the narrative. So it is not that we are turning and whimming to the Western ideals. We are actually looking at how can we advance the legal space in our country through the introduction of various international treaties and the ratification of those treaties. So I think that is my response in regards to the question of whether or not we can maintain the sovereignty as well as do impactful work in our country. Thank you, Judge.
Thank you very much, Madam Julie Matheka. Many issues are coming up, matters like the issue of sovereignty, the issue of the judiciary fund. Many people assume that the judiciary fund is already effective and functional. That is a very interesting topic. I hope one day we'll be able to discuss that. As for today, I would like now I have the privilege and honor to invite Madam Carol Kariuki, who is the CEO of KEPSA. Please welcome.
Thank you very much. Good afternoon. It's actually afternoon now, and all protocols observed. Listening to that question and thinking where business is, so sometimes people look at business very differently. But as an economy, we know we are a private sector-led economy, and our work as the engine of the economy is to create wealth and jobs. So what we do at KEPSA is to actually rally the private sector around not only to speak in one voice and in very different ways, because private sector is busy doing what it needs to do for the economy. It's creating jobs, it's creating wealth, it's doing its social, its CSR in different ways. But when we bring the private sector together, one of the things that we do is actually to work with the 3 arms of government in partnership, with, if it's the executive, the judiciary, and parliament. And that's why we run the roundtables every year. And this is around the policies and laws. And looking from a justice perspective is to ensure that no private sector, whether big, whether it's a startup, whether it's an SME, whether it's a multinational, it has an enabling environment to operate. And that's why we really focus on the laws and the policies. But secondly, the reason why we also bring the private sector is also to look at some of the areas, even as we create jobs, that there are areas that we need to do more and maybe do differently. And especially when we look at the youth. Being a very youthful society, 65% of our population being under 25 is a great resource. But it also can become a problem if we don't target it. And so instead of just waiting for the private sector to create jobs as it creates, what can we do differently? And so what we do from KEPSA side is to run programs around the youth and say what capacities do they need, where do they need accesses, and one of the big programs, and the reason why I'll touch on this one, is the Ajira Digital. And looking at where we are in the world, technology and all, this is where the young people are. They're innovative, they're agile, they're looking to learn, they can do anything. And so what we do is to train them on digital and digitally enabled jobs and help them to access those jobs. But what we have also done with the judiciary around that is to say, what can we help government in the technology side? And so as we look at other parts of the government, judiciary was very fast to come in and work with us on the e-filing system and to really help with the remote case filing and document management. And so we got to employ a lot of the young people in that. But in the process, that has improved justice to the people because of the e-filing and the management of documents and being able to process the cases more. Then also on another different area is the young businesses, and especially the SMEs, who sometimes cannot be able to afford to go through the court processes, and sometimes all they are claiming is less than 1 million shillings. And so working with judiciary again, we worked on the small claim courts, and for me that's been a really great success, because what it has done so far, we've been able to deal with about 68,000 cases, and I'm so grateful to the magistrates and the judges who've worked on this, releasing about 12.6 billion Kenya shillings back to the economy that could have been stuck in the process if we didn't have these small claim courts. Then looking at other things that we do, a lot of, and I'm hoping we can also do this with judiciary, because we've been working, especially the private sector, is better businesses for children. And when we look at a lot of the young mothers, many of them either cannot breastfeed because they have to work, or they have to leave work for many months or sometimes years and lose that opportunity so they can care for their children. And so establishing workplaces for mothers, play places for women, and breastfeed and such places in the organizations has really helped a lot of young women to keep their jobs, but also continue to breastfeed their children for the mandated period when the children can survive on other foods. I'll also give you another example. Look, during COVID, when everything was shut down, and we looked and said, as private sector, what could we do with the health sector? And I can touch on many programs that we did then, but let me mention one, what we called Wheels for Life. Again, a justice issue. And we said a lot of the women who were pregnant that time could not access medical, could not get to hospitals. So we did two things. One, we had a hotline with doctors online who the pregnant women could access for free for any medical information and treatment they needed. But secondly, we partnered with different organizations in the private sector who could transport these women to hospitals during the curfew hours when they could not leave home. And so those are some of the things that we do. And let me mention, I think, maybe one more around this and in terms of what we do in terms of justice. We're running another program with the Bill and Melinda Gates Foundation, and this is the private sector gender-based violence advocacy program, because sometimes we only assume that civil society or government should run such programs, but these things are happening in the private sector. And you said, as part of partnership with others and also with government and civil society, can we do something in the private sector? So for me, when I look at development partners, we're a development partner to government and to civil society in the programs that we work with. But we also work with the development partners who understand what we're trying to do. They do not come and enforce what is happening in their own countries, but we do. When I talk about Nigeria, we've been working with MasterCard Foundation, and when I talk about the better business practices for children, we've been working with UNICEF. And so it's not about them influencing and not adhering to our laws. It's us seeing the need and looking at the partners we can work with, and also partnering with them, whether they're foreign partners, whether they're Kenyan partners, and especially government is our key partner, so that we may create the wealth and jobs that we need as a country. Thank you very much.
Thank you very much. Thank you very much for that appreciation of Madam Kariuki. Thank you very much, Madam Kariuki. We'll come back later with the issue of the questions to the panelists. But last but not least, I would like to invite Mr. Felix Owor, the Executive Director of the LGR, Electoral Law and Governance Institute for Africa, I have particularly to make some remarks or comments about Mr. Felix. Felix is a very good friend through himself and the institution to the judiciary, and in particular to the Judiciary Committee on Elections, of which I'm chair. In fact, as we speak now, I'm only here, I only remain back as a member of the Supreme Court and judge of Supreme Court to participate in this very important event. I opted out not to go to the US as one of the members of the observer mission. My committee, the Judiciary Committee on Election, has been accredited to be a member of the observer missions to the presidential elections in the US. So my vice chair and my secretariat members are there in US as observers. That will tell you that I'm non-partisan in the elections in the US. Thank you very much, Mr. Felix. Mr. Felix supported us in that, our ability to go to the US as observers. Thank you.
Thank you very much, Honorable Chair, and thank you very much for the kind words. My lords, my ladies, distinguished delegates, good afternoon. I was a late addition to this panel, and I don't know to what extent was that decision informed by the outcome of the US elections that the Honorable Chair has mentioned. But I want to believe that to the extent that the judiciary is the custodian of the rule of law, we needed to observe the 1/3 gender rule. My colleagues have spoken at length, and I want to try as much as possible to be very, very brief, given the fact that most of the perspectives shared from the standpoint of development partners and representing organizations such as ICJ and ourselves that work in this sector, our perspectives are very much aligned. But let me start, first of all, by the question on how do we balance the precarious issue of sovereignty. The short answer to that is that in the course of implementation of our programs, we have deeper understanding and respect for the Kenyan Constitution, the Kenyan laws, but also even profound respect to the mandate of the organizations that we work with. You will note, for example, that part of the program that we support the judiciary on elections involve inductions and symposia, including with the various courts, but more so all the way up to the Supreme Court. But even if we do an induction like we did in before the 2022 general elections, and later we did a post-election debrief with the Supreme Court, the minute a presidential petition is lodged, we refrain from calling. I don't even call, and I count myself as being lucky and privileged to know most of the judges from the High Court all the way to the Supreme Court. But whenever a petition is lodged in any court, we don't call. We re-engage usually after the case is determined. So I thought I should say that. Now, I agree with my colleagues that the development partners have been critical pillars to Kenya's development program, particularly in the constitutional, social justice, and the rule of law programs. And my colleagues here, Julie and Anne especially, have given the specific examples, so let me avoid that. But in terms of addition, other than support to the judiciary blueprints that the chair enumerated, including the current blueprint on social transformation through access to justice, the development partners have been critical and indispensable supporters in this sector. But also, the development partners have been very critical in supporting institutional strengthening across the various organizations that work on social justice or constitutional and law reforms area. And even right now as we speak, we are engaged with a number of organizations that are in this sector, including the judiciary, most of this Chapter 15 Commission, as is the case with LGR, ourselves, we work also with the IEBC and other organizations. Now, what are some of the approaches and how are some of the Africa replicating, or how can this be replicated? If you look at, and we take great satisfaction that if you look at, the, for example, the Kenyan judiciary in comparison with others, the Kenyan judiciary ranks high up there. And one of the approaches that we are seeing being replicated in the region is the innovative program under the Judiciary Committee on Elections. Before Kenya established this committee, there was no any other committee that existed to advise the judiciary or to advise the chief justices across the region on matters electoral dispute resolution. But increasingly, and given the work that has been done in this area, we are seeing a lot of positive replication in a number of countries. And as I noted yesterday, after Kenya, Zambia became the second country to establish the Judiciary Committee on Elections Management, and soon after Malawi and the Honorable Chief Justice here became the third country to establish a committee to advise the Chief Justice and the Judiciary on matters EDR. So this is one of the examples where an innovative approach in Kenya is finding replication across the region, given the recognition of the role of the judiciary in resolution of electoral disputes, considering the fact that most of the disputes actually ultimately end up in the judiciary. The other a technical approach that we are seeing resonating very positively, again, Kenya has perfected this, is an integrated program or an integrated process on law reforms. In a number of countries, organizations work in silos. But in Kenya, it is not unique, for example, to find the judiciary in the same hall as political parties, parliament, the electoral commission, and indeed the Chapter 15 commissions, comprehensively discussing the agenda of law reforms. Now, increasingly, we are seeing this practice being replicated in a number of countries in Africa. Malawi will be having its elections next year, Tanzania next year, for example, Zambia 2026. But if you look at some of the programs they are doing, they have adopted an integrated process in the development and considerations of the various electoral laws, or the various laws generally, and that is a practice that was not there before. The other issue is what the Honorable Judge Ibrahim has alluded to, comparative best practices and peer learning. And as evidenced by this distinguished conference that we are having here, we have in our midst honorable judges, chief justices, and indeed from a number of jurisdictions in Africa. Now, fostering peer learning and comparative best practices is something that we encourage, and as noted by the Honorable Judge Ibrahim, we have the rare privilege to have sent or worked with other partners to send the Judiciary Committee on Elections to observe the US elections that is, I don't know whether it's over yet, but it's ongoing. But by the comparative best practices help in acquiring and indeed deepening practical experiences and challenge, and lessons. And then the other issues on integration of technology. I made brief remarks on this yesterday. This is something that is an approach, a technical approach that is gaining a lot of resonance and positive feedback across the continent. As we speak, a number of countries have been asking us and indeed making benchmarking visits to Kenya. How did you deploy technology, or how did you integrate technology as a strategy to access justice and case management? Others are exploiting also live coverage of proceedings. In Kenya, for example, the constitutional petitions or presidential petitions are covered live. And one of the discussions that we're having with Zambia Judiciary, for example, right now, is how can they have live proceedings if a presidential petition is lodged. And then finally is the question of localization. Increasingly, the development partners have come to the realization that you need to build local capacity. That is why USAID, for example, started the Kenya IGAP, which is Kenyan-owned, Kenyan-led, and Kenyan-managed. Support to the electoral process during the 2022 general elections, for example, was led by Kenyan organizations. And I think there's a lot of benefits that accrues when local organizations or regional organizations strengthen to do some of this work that were traditionally being implemented or led by international organizations. But even having said that, we have found very beneficial ways of collaboration and partnership. So I guess I should leave it at that, Chair, and thank you very much.
Thank you very much, Mr. Felix Owur, for your presentation. Now I would like to recognize the Honorable Chief Justices, Honorable Chief Justice Lady Martha Koome, Chief Justice of the Republic of Kenya, and Honorable Deputy CJ, Honorable Philomena Mwilu, the Honorable Emeritus Professor William Tunga. They have rejoined us after their meeting, and with all the other Chief Justices present, welcome back, karibuni. Actually, Honorable CJs, you have found us winding up this panel session, and now it's time for taking a few questions, maybe a couple of questions from the members present. To any panelist here, if you are requested to ask a question or make a comment, then you must specify, as you ask your question, you must specify to which panelist you are directing your comment or question to. We are going to be very brief. Can we have some hands? Can we have anybody who would like to ask a question, comment? I think this session is interesting because people are happy. Yes, I can see one hand there. With this lighting and the issue of shadows, I picked that hand. Who is that, please?
Thank you, my Lord. My name is Lilian Arika, the Registrar KJ.
So we'll have one there, and I saw another hand this side. Did they see another hand this side? Any other hand? Any other? Yes, I can see at the back. Yes, can you stand up at the back? You state your name so that I can remember. Very briefly, please. I'll start with Honorable Arika, who was my secretary at the Judicial Committee on Elections for many years. Let's start with Honorable Arika.
Thank you very much, my Lord, and thank you for the opportunity. Mine is not a question, but to appreciate the partners, and thank you for the recognition, my Lord. I am currently the Registrar Kenya Judiciary Academy, and I'm happy that the Director General Kenya Judiciary Academy, Honorable Justice Mokin Wanjala, is here. Ours is to say thank you very much. The panelists, the dais, are one of our biggest partners. I know some are also seated on this other side. Without your support, we cannot do much of what we do. Capacity building for the judiciary, judges, magistrates, and judicial officers. We continue to count on your support, and we thank you very much for continuing to walk that important journey with us. Thank you.
Thank you. Actually, that is a recognition that you deserve, members. The other gentleman at the back, I didn't get the name.
Good afternoon. My name is Kamundia Gitahi. I'm a student of law at Trier University, and my question is to the CEO of KEPSA. Earlier in the year, I don't remember whether it was a survey by KEPSA, but it was by the private sector, and I think the demand for people in the legal profession was around 18%. So as a law student and as young people, of course, we want to know what is our space in the future. So we would like to know, even as we discuss partnerships, are there particular areas of law which you would advise young people to go into, maybe because there's a demand for lawyers in that sector, maybe it's commercial law, maybe it's human rights, so that we can know where perhaps we should be aiming at. Thank you.
Thank you very much for that. I can see that that is the last question or comment. Thank you. Now I return to the panelists. I think one was really recognition of the support you have given us from the Honorable, who is the Chief Magistrate and a former Secretary to the Judicial Committee on Elections, and who dedicated for many years to serve that committee. There is that question that has just been raised by the young gentleman student. I think I'll ask one of the panelists. I think he directed to KEPSA. Thank you.
Thank you very much. That's a good question. I don't remember the study, the details of the study. I need to maybe look at it, but I don't think it was from us, but maybe from one of our members. But in terms of the legal fraternity and where to focus on, I don't think there will be any time that businesses will never need commercial law and anything around company secretary and all that. So the legal fraternity does not have a dim future in the private, in terms of jobs in the private sector. There'll always be jobs that will be available. I think the difference is that now the legal fraternity has to embrace internet technology, because everything with AI, so it will be different. And so what I think, as I mentioned about technology and why we are very keen on digital and digitally enabled jobs for young people, is because we see the future of jobs there. I've always said that the technology is not here to take away jobs. It actually increases jobs, but it's how we embrace it and how we use it that increases those jobs. And so I would not have fear if I was a law student. What I would be fearing is embracing law as it has been practiced in the past and forget to embrace it as it is moving into the future with technology.
Thank you very much, Madam Kariuki. And honorable members present, honorable CJs, Chief Justice, this brings us to the end of this session, of which has been chairing. Please, can we have a deserving applause for the panelists? Thank you very much, the panelists in this session. Thank you for coming. Thank you for your time. We really appreciate it. It has been an honor working with you, presenting with you. Thank you. I now take you back to our MC, Rosa Shuka.
Thank you very much, my Lord, and particularly for moderating that conversation. I'm told by the conference director that the proceedings of your panel, my Lord, will be availed to our Chief Justices, who just came from the Chief Justices Forum, a very, very exciting Chief Justices Forum, which started this morning. Honorable Chief Justice, we beg a 5-minute break to reorganize the room for the closing ceremony. So with your permission, we can take a stretch break and then be back at exactly 35 minutes past the hour so that we can get into the closing ceremony. Thank you very much. 5-minute stretch break. And I will request our protocol team to be ready to reorganize the room. Thank you.
In a nation where the rule of law is a cornerstone of democracy, one institution stands tall: the Supreme Court of Kenya. For 12 years, as an arbiter of justice, it has respected, upheld and protected the Constitution. Join us as we journey through a decade of defining events. The Supreme Court was born from the aspirations of a nation. It was a bold step towards a new era of justice and accountability. The establishment of the court was intricately tied to Kenya's constitutional rebirth. It was created to safeguard the transformative promises of the Constitution by being a final arbiter of legal issues.
The Supreme Court was established after the promulgation of the Constitution of Kenya 2010, following a clamor by Kenyans that they required an apex court that could settle with finality certain complex matters like with expediency, like the presidential election dispute. The Supreme Court has also settled many issues involving the application and interpretation of the Constitution, which is an original mandate given to the Supreme Court.
There were so many challenges in terms of democratic governance, which started, of course, with the Independence Constitution, the 1964 Constitution, and with the Constitution amendment starting the introduction of multi-party. There were amendments in 1997 to open the space for electoral democracy. A failed referendum in 2005 when Kenyans said no to a new constitution, to the elections of 2007. And as a result of that, they created what they call the Agenda 4. And one of the agendas was to create a new constitutional dispensation.
The entry of the Constitution 2010 of Kenya came with a fundamental shift in the constitutional architecture of the country. The Supreme Court of Kenya, as the apex court, was established to inject new judicial philosophy and develop indigenous jurisprudence that aligns with the new constitutional provisions.
I was lucky to have been appointed a member of the Constitutional Review Commission of Kenya. Kenyans were particularly concerned about the judiciary at the time, that the Court of Appeal as a final court at the time was not sufficiently capacitated to handle matters of national importance with finality to the satisfaction of Kenyans. They also said they want a court which would be above the Court of Appeal at the time, a court that would then have the confidence of Kenyans that when you've exhausted the legal mechanism, you receive justice at the highest level, which would be the Supreme Court. So that was the history and the reason why the Supreme Court was created.
The Constitution under Article 163(1) established the Supreme Court as the apex court in Kenya with the following mandate: A. Exclusive and original jurisdiction to hear and determine presidential election petitions. B. Hear appeals from the Court of Appeal on both matters of general public importance and interpretation and application of the Constitution. C. Hear appeals by judges from tribunals formed for their removal from office. D. Render advisory opinions. And E. Determine the validity of declarations of a state of emergency. Following a competitive and open recruitment process by the Judicial Service Commission, the inaugural bench of 7 judges of the Supreme Court was appointed on 16th of June 2011 by His Excellency President Mwai Kibaki and assumed office on 26th of August 2011. Over the years, the composition of the bench has undergone changes. Once Chief Justice Dr. Mutunga's term in office came to an end, Chief Justice David Maraga was appointed thereafter in 2016 and served until 2021.
I, David Kenani Maraga.
Also, following the exit of Deputy Chief Justice Dr. Nancy Barasa, Lady Justice Kalpana Rawal was appointed in 2013 and served until 2016.
I, Martha Karambu Kome,
The current bench is under the leadership of the Chief Justice Martha K. Koome, who was appointed in 2021.
The judiciary required massive transformation of its operations for it to meet the tenets of that constitution. My predecessor, Dr. Will Mutunga, started that with the blueprint of judiciary transformation framework, and I laid the basis. When I took over, I built on what he had started, enhancing service delivery and ensuring that parties are able to access justice freely.
I think we are the best performing court. We are almost real time. When you file a matter, especially an application, it will be handled and disposed of within 3 months. The petition of appeal will be disposed almost in a year's time.
Because of our refined jurisdiction, since 2011, when we first sat, there's been filed a total number of 680 cases of all natures, applications, petitions, and advisory opinion. As we speak today, we have settled them except for 41.
At the beginning, we didn't have advanced technology, ICT, that we have now. Everything was manual. Now we do even virtual hearings, and we are able to dispose of cases quite fast.
The court has done a great work. The foundation that was laid by the pioneer judges and that continues to be built by the current judges ought to continue. The kind of jurisprudence that we are churning out that are cited across the world ought to continue.
Over the years, the Supreme Court has delivered landmark judgments, developing a rich and indigenous body of jurisprudence that reflects the spirit of the Constitution while addressing the evolving needs and demands of the Kenyan society.
In the revenue allocation case, the Supreme Court clarified the role of the National Assembly. The Supreme Court clarified the role of the Senate. The Supreme Court clarified the role of county governments.
BBI report itatekeleza mikakati ya kuboresha maisha ya Wakenya wote.
The Building Bridges Initiative case to amend the Constitution was very emotive. The country was divided. It had brought a lot of tension.
Yes.
And the Supreme Court was able to determine it with finality.
The Supreme Court's decisions, for instance, in the areas of of environment and land, have been clear. I refer to decisions such as Mitubel and Kenya Airports Authority, for instance.
The 2017 Supreme Court decision made it very clear that unless the electoral process was done in accordance with the Constitution, the court would set it aside.
We have made decisions on the removal of judges, separation of powers when it comes to advisory opinion that we've given.
We made a landmark decision in criminal law where we declared the death penalty, the mandatory death penalty, to be unconstitutional. Relating to family law, many people call the come we stay a marriage, when in actual fact it is not. You are not married, you have purchased this property together, you are no longer together. What then happens? So it was a lacuna in the law which the Supreme Court has settled.
Yes. There is something called collegiality. Collegiality means aspect of each one of us contributing as much as they must to the determination of the case, and the rest of us respecting each other's ideas and the fact that the decision has to be the decision of the court, not of one, not even of the 5, but of the 7.
The journey has not been without its challenges. But through it all, the Supreme Court has remained steadfast in its commitment to justice. It has faced criticism, withstood pressure, and emerged stronger.
me first challenge the number of judges in the court. A few years back, the court faced a challenge. Judges had retired. One judge is unavailable to sit, so suddenly we had 4 judges. That is exceedingly dangerous.
Then we were swamped with a bewildering array of legal issues, of constitutional issues. What would be the appropriate date to hold the first general elections under the 2010 Constitution, for example?
The biggest challenge we face today is unwarranted criticism. We do not get positive criticism that can help us develop. What we get is our insults in social media, in the mainstream media, and that's something that can weigh down on human beings.
The time for hearing is so short, the evidence voluminous, and then there's preparing submissions, and finally for the judges to retreat. Sometimes we retreat only for 2 days. We should have at least 60 days. Minimum, in my view, 45 days.
The Supreme Court has no home, and it is our priority to build a Supreme Court. We are seated in an old building, the museum, where we have no space. So we have plans to build the Supreme Court of Kenya.
The court strives for excellence in its case management, from scheduling hearings.
We're ready? Colleagues, please support us in ensuring that our guests are back in the room so that we can get going on this closing program. We are ready, colleagues? Welcome, Honorable Chief Justice. Honorable Chief Justice is present. May I request that we settle back into the room? We are 15 minutes behind schedule, but I know that we will catch up and make sure that the closing ceremony is as colorful as it should be. May I request our colleagues standing outside of the main conference venue to settle back into the room so that we can commence the program. Let me invite the chair of the session, Honorable Justice Isaac Lenaola, to commence this session for us.
Thank you very much. Thank you very much, Rose. Honorable Chief Justices, distinguished judges, participants, my role now is to say a few words in gratitude to all of you
on behalf of the Supreme Court of Kenya before we go into the closing ceremony and the gift giving ceremony. And I have a few words to say, and they're as follows. As we draw this enlightening conference to a close, it is my privilege to stand before you and express our gratitude on behalf of our Chief Justice, on behalf of the judges of the court, the entire court, and the entire judiciary of Kenya, to all of you for being here. Let me thank our keynote speakers and panelists who shared the invaluable insights over the past few days. Your expertise and perspectives have not only enriched our understanding, but have also challenged us to think critically about the vital issues facing our legal system today. Our Chief Justice says particularly you missed a wonderful session on technology, and I hope that you will at some point receive part of the conversation we had with our techies this morning. Let me thank the court for hosting the conference and for its commitment to justice and the rule of law. I think you have seen what stuff this court is made of. And to the leadership of the court, the Chief Justice and the Deputy Chief Justice, we thank you for your vision and as being an inspiration to us all. Let me thank our sponsors and partners, Kenya Commercial Bank, Conrad Admiral Foundation, ICJ, and the rest who have generously supported this conference. Your contributions have made it possible for us to come together, share our knowledge, and foster collaboration within the greater legal community. To all the participants, lawyers, judges, academics, scholars, students, and I'm happy that our students are here today. Thank you for your engagement and your enthusiasm. Your active involvement and thoughtful questions added immense value to our discussions and will surely resonate in our future endeavors. Let me also thank the organizing committee, co-chaired by Lady Justice Njoki Ndongo and myself, all the staff from the various courts and places within the judiciary, and even our volunteers whose hard work and dedication have made this conference a success. Your tireless efforts behind the scenes and chief justices and judges from other jurisdictions, you saw the protocol, the security, the drivers who stood by you since you came here and until you leave. Your efforts have not gone unnoticed. And as we conclude, going to the last session, let us carry forward the insights we have gained and continue to work together towards a more just and equitable society. May we all depart with renewed passion for our roles in the legal field and the judiciaries, and a commitment to uphold the values we so hold dear across our judiciaries. And so thank you again. Thank you all so much. Safe travels as you return to your respective destinations, and see you at the Supreme Court of Kenya at 20. Thank you very much.
Thank you very much. Thank you very much, my chair, the chair of the session, and my co-chair of this wonderful Supreme Court at 12 conference. Another round of applause. I think as we close, let us close on a high. So we are getting into celebration, celebratory mood. So let's also, be very jolly, jovial to close this in style. Now the next session is the award of gifts to the winners of the inaugural Supreme Court Moot Court competition. The inaugural Supreme Court Moot Court competition had 16 universities participating, 48 students, and we will know who the winners are shortly. I will request and thank our visiting Chief Justices and judges for awarding these finalists, and I will request that when we call a team, please make your way to the stage. And then I will call the distinguished judge who will grant the award, and I will guide what we're going to do so that we can memorize this occasion. So, we will start with the best male oralist. The best male oralist was Mavis Ndubi. Mavis, best male oralist. Mavis Ndubi reminds me of myself 20 years ago when I was an ardent moot court participant at Moi University. So I'm very proud that he is keeping the tradition of winning in Moi University. So let us applaud him once more. So Mavis, please, may I welcome you to the stage. And to award Mavis, I will welcome the Honorable Chief Justice from Malawi, my Lord. I know Mavis has ambitions to serve in the nation and the region, and so this is a moment of great honor as he receives the award of Best Male Oralist. Mavis Ndubi, Moi University. Mavis will receive an official certificate. Camera people, let's make sure that the photo can be used by Mavis for bragging rights. He deserves it. He will also receive a phone courtesy of Safaricom, a mobile phone, and I'm sure that Mavis will join the admirers and defenders of the Supreme Court on social media. And in that phone is 2,000 airtime. So we are setting him up with 2,000 airtime. And ladies and gentlemen, it is a Samsung Galaxy A15, Samsung Galaxy A15. Courtesy of our Chief Justice Emeritus, Chief Justice Willie Mutunga, Mavis also will go home with a book, Beacons of Judiciary Transformation, a selection of speeches, writing, and judicial opinions. He also takes away a book in search and defense of radical legal education, which Chief Justice Emeritus delivered as inaugural lecture. Louder, please. Can we hear a louder applause from University of Nairobi, please? Next is a very special lady, an upcoming legal jurist, best female oralist, Winjoy Gitonga. Winjoy redeems the great University of Nairobi. But I have to say, even I really, really admired our two oralists. So Winjoy, please go up on stage. We are continuing to see women get their rightful position on the African continent. And therefore, I will welcome Honorable Lady Chief Justice from Ghana to give this award. It is important for us to see women winning. They may not win globally today, but we are seeing them winning. We live to fight another day. Winjoy gets a Samsung Galaxy A15, Samsung Galaxy courtesy of Safaricom. She also gets a certificate, 2,000 airtime, and a book courtesy of Chief Justice Emeritus, Professor Willie Mutunga. Winjoy Gitonga, University of Nairobi. Thank you, my lady. Thank you, Winjoy. We now move up to the second runners-up. Second runners-up, Africa Nazarene University. Africa Nazarene University, Lucy Omoyo, Yvonne Auma, Amani Andika, and Shemaya Close. Let's make our way to the stage. African Nazarene University, second runners-up. The Supreme Court Moot Court competition will be an annual event. Please let us appreciate them. I will invite another phenomenal lady on the continent, the Honorable Chief Justice from Liberia, to give this award. Each of the participants will get a Galaxy 5, Galaxy A5, courtesy of Safaricom. My lady, please let us appreciate Honorable Chief Justice as she comes on stage. Each of the participants will get a Samsung Galaxy A5, airtime of 2,000, and certificates. A certificate to Lucy Omoyo. Lucy, congratulations. A phone, Galaxy A5. And a books courtesy of Chief Justice Emeritus Professor Willie Mutunga. Next we have Yvonne Auma. Thank you, band. Let's keep doing that. Yvonne Auma, a certificate, Galaxy A5, and we have agreed this Galaxy A5 will be put to use on social media to talk about Supreme Court jurisprudence. Thank you, Safaricom. Thank you very much. Aman and books courtesy of Chief Justice Emeritus. Amani Andika. If you're on Oxford Street, it will be Armani. Amani Andika, a certificate, Galaxy A5, airtime 2,000, and bragging rights. Shemaya Claus, thank you. Thank you, Chief Justice. We have Shemaya, finally. Shemaya Claus, yes. You will also get a phone. Shemaya is the coach, the team coach. So he will get a book courtesy of Chief Justice Emeritus, and we will give that to him. African Nazarene University, thank you and congratulations. My lady, thank you. In position number 2, we have the University of Nairobi, Team Herbert Wandeto, Winjoy Gitonga, Edwin Deng, and the team coach, Samson Alosa. Herbert Wandeto, Winjoy Gitonga, Edwin Deng, and Samson Alosa. The University of Nairobi. And for avoidance of doubt, this is the Supreme Court University. Many of our judges went to this great university. I will invite Your Lordship, Honorable Chief Justice of the Kingdom of Eswatini and the Chairperson of the Southern Eastern African Chief Justices Forum to present this award. It is the university south of Limpopo, so it is very iconic to have Chief Justice of the Kingdom of Eswatini give this award. And our winners, our first runners-up, will get a Galaxy A15. Galaxy A15 to Herbert Wandeto. Congratulations. A certificate. And books courtesy of Chief Justice Emeritus. Congratulations, Herbert. The future is very bright. Winjoy Gitonga. Again, a Galaxy A15, so Winjoy gets a phone for herself. phones, actually. Galaxy A15, a certificate. Airtime of 2,000, all courtesy of Safaricom. Thank you, Safaricom. Then we have, congratulations, Joy. Edwin Deng. Edwin Deng, congratulations, a round of applause. A phone, Galaxy A15, a certificate, and literature, courtesy of Chief Justice Emeritus. Congratulations, Deng. Congratulations, thank you very much, Your Lordship. Let's have a group photo. His Lordship in the middle. Congratulations. There is no doubting that the University of Nairobi is indeed a great, great institution, and we are very proud of you. Thank you very much, Your Lordship. Congratulations, team. I'm being corrected by my brother that the name is Hubert Wandeto. Hubert Wandeto. My apologies. In first position, are we ready? Are we ready? We are not ready. Are we ready? In first position is a university that keeps on rising, and it has fallen many times. But we keep on rising. Okay? And I hope that the commitment displayed by the students will require us to commit to the university more to make sure that it succeeds for the next century and many more years to come. The second law school to be established in Kenya, and now first among equals, Moi University. Moi University, and dare I say that they have the best advocacy curriculum in the country. The best trial advocacy, and it is evident in the results that we are seeing today. Jonathan Dolo, Mavis Ndubi, Laura Bina, and team coach and my classmate, Dr. Joseph Omwara. Please, take your time. We will wait on you. You deserve it. Please, winning team, Jonathan Dolo, Mavis Ndubi, Laura Bina, and team coach, Dr. Joseph Wamwara. Best overall team at the inaugural Supreme Court Moot Court competition. But you have to keep that position. So next year we'll see. We'll see if we continue celebrating. It is my distinct pleasure and honor to invite Judge President of the East African Court of Justice to give this award. Out of 48 students, 16 teams, this is the winning team, Moi University. But I have to say that the difference was very marginal, just showing the caliber of law schools that we have and the caliber of students that we have. Marginal difference. Jonathan Dolo gets an Oppo phone, the latest in the market, courtesy of Safaricom, 2,000 airtime, a certificate, and literature. Oppo phone, and I know that my age mates understand what it means to have the latest Oppo phone. We can communicate even more now. Congratulations, Jonathan Dolo. Next is Mavis Ndubi, an Oppo phone, a certificate, a 2,000 airtime, again, courtesy of Safaricom. Laura Bina is next. Congratulations. Mavis also gets 2 phones. His and for a person of his choice. Congratulations, Miss Bina, and congratulations to the entire team. Yes, let's make sure the photo is perfect. I like that, you see? Congratulations. Congratulations, let's have a group photo. We can balance it so that Miss Bina is with his lordship in the middle. That's a perfect photo. Maybe we can come a bit so we can see the backdrop. There you go. Let's take that photo, which we will proceed to share with the management and everybody who has to save our beloved university. Congratulations, band. Let's see it a little more louder. Thank you very much. There cannot be a winning team without the best applicant memorial pleadings. You cannot have a successful case if you do not provide excellent pleadings. And awarded Best Applicant Memorial. Best Applicant Memorial is Jomo Kenyatta University of Agriculture and Technology. They had the best pleadings. Francis Brandet, Abdirahman Abdi, please come forward. Maureen Danu, and team coach Dennis Ndabo Daktari. Best Applicant Memorial, best pleadings in the case. To award, please come forward. Let's have a round of applause. These are the opportunities that we wish we had, and thanks to the Supreme Court of Kenya, our students know that excellence deserves reward. Congratulations. May I request, with respect, Chief Justice Emeritus Willy Mutunga to award the Best Applicant Memorial. The team will get literature courtesy of Chief Justice Emeritus. We have books courtesy of Chief Justice Emeritus. Certificates. So let's have certificate for Francis Mbredet. Francis, congratulations. Francis will also receive 2,000 airtime courtesy of Safaricom and books courtesy of Chief Justice Emeritus. Certificate for Abdirahman Abdi. Congratulations, Abdirahman. Certificate for Maureen Danu. They also get a book. Let's have Maureen's certificate. Maureen Danu. And each will get 2,000 airtime and books courtesy of Chief Justice Emeritus. Let's have a group photo. We have the team coach, Dr. Dennis Ndabo. Team coach. Congratulations, sir. We celebrate you. Let's have, they will all get books, and we can get the books when they settle. But let us now have a group photo. Congratulations. It's a really, really great book. It's a really great book, so be sure to read it. A group photo. Let's have congratulations to Jomo Kenyatta University of Jomo Kenyatta University of Agriculture and Technology. I have to say that they also had the best respondent memorial. The same team had the best pleadings. Thank you, Chief Justice. Congratulations, team. I will also recognize our moot court judges and court assistants, and we'll invite all of them to come up stage. Our moot court judges, Honorable Letizia Washira, Honorable Bernard Kasavuli, Honorable Joan Obilianga, Honorable Charles Kutwa, Honorable Agnes Mwangi, Honorable Nelly Kariuki, Honorable Zainab Abdul, Honorable Charles Ondieki, Honorable Gerard Gitonga, Honorable Hosea Nganga, Honorable Evelyn Kenyua, and our court assistants, Esterina Mwende, James Nyuguto, Abel Leting, and Benjamin Kongoi. This is the team of judges that facilitated the judging of the moot court competition, and we recognize you. Our judges will also get a token of appreciation, courtesy of Chief Justice Emeritus, Professor Willie Mutunga. They all will get a copy of Chief Justice's book. May I request Chief of Staff Emeritus, Duncan Okello, to facilitate the distribution of the books to our judges, and request Chief Justice Emeritus for a photo moment with our judges and the books. Chief Justice. Let's appreciate our judges, please. The judges of the moot court competitions. Let's come closer. Congratulations to you all. And we are very, very grateful to Chief Justice Emeritus for the gift of the books. Let's appreciate our judges. Thank you very much. Thank you, Chief Justice. The Chief Justice has also provided books, and that those will be distributed as we continue with these proceedings to all our visiting Chief Justices, visiting Deputy Chief Justices, visiting Superior Court Justices. So we will also give the books to our visiting Chief Justices, Deputy Chief Justices, and visiting Superior Court Judges. So with that, that brings us to the close of the awards to the winners of the inaugural Supreme Court Moot Court competition. And on behalf of the Registrar of the Court, Asanteni Sana. Asanteni Sana. I think that it's a great, great mentorship program by the Supreme Court. I wish I could go back to law school, but I had my time. I too was mentored by the court, and we will always be grateful for the opportunity to train young lawyers into the great jurists that will become courtesy of that partnership. Again, a round of applause to the Supreme Court, our Supreme Court. Now, to give us the official closing remarks, it is a distinct honor to welcome Honorable Lady Justice Philomena Mbete Mwilu, Deputy Chief Justice and Vice President of the Supreme Court of Kenya. My lady.
The Chief Justice and the President of the Supreme Court of Kenya, Honorable Chief Justices and Deputy Chief Justices from across Africa, my brother and sister justices of the Supreme Court of Kenya, Honorable Justices of Superior Courts here present, the Chief Registrar of the Judiciary, and the judicial officers present, distinguished speakers, panelists, discussants, and moderators, eminent delegates, and participants, and all that we invited to our day. Ladies and gentlemen, good afternoon. I am honored to address you today at the close of the participation and after 6 days of lectures, moot court competitions and symposium. I can confidently say that the theme of the conference, Introspecting and Reflecting on the Supreme Court's Jurisprudence, 12 years of defending the Constitution, has been befittingly ventilated. The last week of events has exceeded the expectations we had at the point of conceptualizing this commemoration. I'm humbled and grateful for the nature and quality of the engagements we have had over the week. This began with the excellent submissions and advocacy showcased by our budding jurists during the moot court competition. Drawn from 16 law schools, undergraduate law students submitted memorials and over 3 days debated over a moot question that had been shared in advance. The finals were held in court before a 5-judge bench of the Supreme Court of Kenya. And the Supreme Court of Kenya awarded points to the competitors. All the brilliant young legal scholars showcased a deep understanding of the Supreme Court's jurisdiction and the jurisprudence emanating from Kenya's Apex Court. Indeed, so successful was the moot that the Supreme Court has decided that it will be held on annual basis. This is in the very best spirit of learning and mentorship as espoused by the court, and is part of our commitment to deepen our interactions with the academy and in particular young legal scholars at law schools across the country. I sincerely thank the lecturers and staff at the various law schools for facilitating and preparing the students for the moot. We appreciate the seriousness with which you took this exercise that was reflected in the illuminating and insightful memorials that were submitted. The dedicated participation of all that were involved and the quality of advocacy showcased throughout the competition. I thank and applaud all the students who took part and once again recognize and congratulate the winning team from Moi University, the best female oralist, Winjoy Gitonga of the University of Nairobi, and the best male oralist, Mr. Mavis Ndubi of the Moi University. Shall we appreciate them once again? Friends, His Excellency the President graced and officiated on the opening ceremony. With him were His Excellency the Deputy President. On behalf of the Right Honorable the Speaker of the National Assembly was the Majority Leader, and the Prime Cabinet Secretary was in the House. The Honorable the Attorney General, the titular head of the legal profession, was here, and the Governor of the County of Nairobi was present. We heard all of them. I believe the stature and breadth of representation reflects the recognition across all state organs of the key role the judiciary and the Supreme Court in particular continue to play in the realization of our collective aspiration for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and importantly, the rule of law. Since the opening session, we've enjoyed 9 sessions on purposefully selected themes. I'm sure you would agree that the moderators and the panelists have been excellent. Our Chief Justice and Chief Justice Emeritus reflected on the court's evolution, milestones, challenges, and opportunities. In the second session, the Honorable the Chief Justices of the Republic of Ghana and the Republic of Malawi shared on the traditions of courts and practices and experiences in their jurisdictions towards the demystifying of apex courts. The Honorable Justice Professor Dikange, Judge, I hope he's still around, Judge of the National and Supreme Courts of Papua New Guinea, was joined by Bwana for a very illuminating third panel session on navigating judicial independence and accountability in the context of the Supreme Court's politically sensitive jurisdiction. During yesterday's 4 sessions, we focused on the jurisprudence of the Supreme Court with expert analysis and wholesome critique of the content and import of the Supreme Court's decisions in regard to constitutional interpretation, socio-economic rights, criminal law, and family law. And today, we further benefited from discussions on technology, human rights, and on the role of development partners in supporting the realization of the constitutional socio-economic justice promise. Each of these panel sessions were augmented by excellent comment and query from the plenary, all of which have contributed to a deep and substantive introspection and reflection on the work of the court these past 12 years. In what I think you will agree with me was a fantastic opening remark from the Honorable Lady Justice Njoki of the Supreme Court. We were told that a key objective of the conference was to facilitate honest and open engagement with our stakeholders, coupled with objective peer assessment from our sister judiciaries in the region and globally towards assessing our progress as a court and to ensure that the court remains on course in the service of the people of Kenya as a guardian of the 2010 Constitution. I think this objective has been met. There's so much fertile comment, critique, and opinion with which to enrich our introspection and reflections as a court. Even at this stage, I can confidently say that the Supreme Court, and by extension our constitutional democracy, will be the better for this 7 days. I, and no doubt my colleague judges on the court, cannot wait for the post-conference debrief, during which we shall further crystallize the key take-homes of the conference. We were particularly pleased that a cross-fertilization of ideas has taken place across jurisdictions. This provides our court with especially useful and diverse perspective, knowledge, and experience. I thus extend a most special word of gratitude to the Honorable Chief Justices, Deputy Chief Justices, judges and juries from sister judiciaries in the region and from across the world for honoring us with your presence, physical and virtual. We do not take this for granted, and we hope, as you continue to deepen and strengthen justice and the rule of law through your respective courts, judiciaries, and jurisdictions, we too may have occasion in the future to visit and conclave with you in celebration and acknowledgement. I sincerely thank all the presenters and experts for their presentations and contributions during this great conference. Our sincere gratitude also extends to our partners for their steadfast support. To our participants from outside of Kenya, I hope you enjoy the rest of the stay in this magical Kenya. And thereafter, we wish you all safe travels back home. And please convey the greetings and best wishes from all of us in Kenya, and in particular from the Supreme Court at 12. Our thanks and appreciation to the Honorable Lady Justice Njoki, our Supreme Court Justice, and the Honorable Mr. Justice Isaac Lenaula, Supreme Court Justice, for co-leading the committee that organized this event. Thank you. I thank the court's registrar, the Honorable Letizia Washira, and her team for facilitating the success of the Supreme Court at 12 celebrations. Thank you. This was team effort, involving numerous personnel from all cadres and across various courts, directorates, and units. Indeed, over the past 12 years, the court would have achieved nothing without the dedicated and dutiful corps of judicial officers and staff who ensure that the justices of the court are able to execute their mandate. Since 2010, the court has been served by 6 registrars. The Honorable Esther Nyayaki ably served the court for 8 years immediately before the current registrar. Before her, the Honorable Njeri Thuku and the Honorable Martin Muya, now a judge of the High Court, all served in acting capacities, contributing to the setting up and establishing this nascent court. Assisting them have been deputy registrars and judiciary staff, without whose commitment and service there would be no Supreme Court at 12. We thank you. We acknowledge and thank you all very, very sincerely. I congratulate the President of the Supreme Court, the Honorable the Chief Justice, on the occasion of this commemoration. Well done, all the justices of the court, and congratulations once again on the roles you continue to execute daily in the service of the people of Kenya in the delivery of justice. As we introspect and reflect on the work of this court thus far, may we rededicate ourselves as a bench and as a court to our constitutional duty and the oaths that we pledged
to forever remain cognizant of the solemn duty and responsibility to the people of Kenya, from whose delegated authority we have derived our judicial authority. My brother and sister justices, ladies, and very many remarks, it is now my distinct privilege and honor to declare the Supreme Court at 12 conference officially closed. Thank you for being here for us, and may God Almighty bless us all on the court, bless the Judiciary of Kenya, bless our friends from Africa and from across the globe, and bless the Republic of Kenya. Thank you very much. It's my distinct honor to invite the first 2010 Constitution Judiciary Chief Justice, the Honorable Mr. Justice William Munyoki Mutunga, to officially close the conference for us. Chief Justice Mutunga.
Close. Good afternoon, Chief Justice Kome, visiting Chief Justices and Deputy Chief Justices, visiting judges, ladies and gentlemen. Let me ride on the protocols the DCJ has established. Let me thank the Chief Justice Kome for asking me to make these closing remarks. And before I do that, let me congratulate the students on their awards. And please read chapter 4 of the Beacon's book. I have an article there on the legal profession. It might help you as you wade into that profession. Now, as we draw this insightful conference to a close, I would like to take a moment to reflect on the profound discussions we have had over the past few days. The Supreme Court, as the highest court in the nation, is a court of last resort, but is also a beacon of hope for those who seek justice and a platform for the protection of fundamental rights. Therefore, it has vital responsibility to interpret the law and actively shape its evolution in a manner that is just and equitable. However, the challenges the court faces have been to continue to be complex and multifaceted. We must build on the gains and rescue the weaknesses. Thus, the topics we have explored have been relevant and quite timely. We have deliberated crucial topics ranging from judicial independence and accountability, electoral jurisprudence, devolved governance, criminal law jurisprudence, and case law on family issues, and so many more. It's my belief we all stand better informed and more appreciative of the work and processes of the Supreme Court. First, I want to express my heartfelt gratitude to the judges of the Supreme Court for organizing this conference and creating a forum for sharing and reflecting on its role and decisions. I appreciate their acknowledgement of the need to continuously
build public trust in the judiciary, and how clearly with the community to better understand its needs and expectations. Second, I also thank each one of you, the judges, judicial officers, legal practitioners, scholars, and civil society representatives, as well as the online audience. Your insights and experiences have enriched the discussions. More importantly, your presence and attention during the conference speak volumes about your faith in the justice system, as well as your deep dedication and shared commitment to assist the Supreme Court to improve its processes and delivering decisions that continue to serve and resonate with the people of this great nation of Kenya. I've been both a believer and champion of the necessity of continuous reform within the judicial system, because justice is not a privilege but a right for Kenyans. Therefore, it's my hope that the Supreme Court will take all the insights they have received during the conference and work to continue to enhance its accessibility and responsiveness to the needs of the public. The court must ensure that justice is not only done, but it's seen to be done. I want to emphasize that a strong and independent judiciary is vital to the foundation of a flourishing democracy. And as we look to the future, let us remember the pursuit of justice is a continuous journey, one that requires resilience, innovation, courage, and unwavering commitment. We must all continue to strive to be up to the task on various capacities. I urge each one of you to remain advocates for justice and catalysts for the change in our communities. In closing, I need to share a few more insights on some of the issues discussed. An excellent introspection and reflection by the Supreme Court of this nature should require a great deal of input from other superior courts. As part of these celebrations, the Supreme Court should feel sufficiently confident to have a joint session with other superior courts and engage in a family, good-natured conversations on the emerging points of jurisprudential convergence and divergence. This is because the Supreme Court may be supreme, but not infallible. And therefore, a learning posture is an imperative, especially where the Supreme Court overturns decisions that have been agreed on by the High Court and the Court of Appeal. Those other levels of courts would draw important lessons in this jurisprudential dialogue, and I would urge the Chief Justice and the President of the Court of Appeal and the President of the High Court to have this convening. The Supreme Court and the judiciary in general should realize that it is the last frontier in the protection of public interest. It is essential that the court develops and animates that consciousness. Judges and judges of the new sovereign, the people, and the courts are established to grant relief to that very public. By design, they are established knowing that other arms of government can and do abuse their respective powers. Courts must check that power and eschew tendencies and temptations of judicial appeasement as guided by the Constitution and the law. We need to set up a common platform for shared jurisprudence of all superior courts in the continent. One country might choose to host it. Kenya has a robust law reporting digital platform, NCLR, and can, in the first instance, offer this service to other countries. It is an award-winning platform. We could eventually create a continental platform with necessary headquarters agreements. but we could start here. And this is something I shared with Chief Justice of Ghana, because I think an institute for continental jurisprudence can be established in Ghana, and could be appropriately be called Nkrumah Institute for Pan-African Jurisprudence. The office, I wanted to say this because, as you know, there are now 2 offices of the former CJs that have been abstract, but now we are getting funding, and these offices, although we have to decide what their role is as public offices, they must protect the independence and integrity of the judiciary at all times. I know there are certain things that the judiciary can't say, can't protect itself, and I know the judiciary values its critics, which I think is a good value, but the offices of former CJs should be in a position to play that role of protecting the independence and the integrity of the judiciary at all times. I know institutions and judicial arms are never safe, but the judiciary is the big sister and brother of all institutions in this country. And I know the executive and parliament think that judiciary is not an arm, but an arm of state, but they think we are a stamp. We must not allow ourselves to fail. We are the only national institution that has the greatest opportunity of setting this country on a patriotic constitutional trajectory. Thank you very much for listening to me.
Thank you very much, Chief Justice. May I request that you remain on stage? We recognize, Honorable Chief Justice, that you chair the Africa Judges and Jurist Forum elders.
Yes.
And we want to request our visiting Chief Justices and our Chief Justice to join you on stage for a special pic photo to commemorate this event, as well as to receive your gift of the book, which really has nuggets of beacons of judicial transformation that are immortalized in the philosophy of our post-2010 judiciary.
Thank you.
It is truly powerful to continue to see convenings of Chief Justices and structures that they continue to create to ensure that judiciaries are not stamps, but arms of government. Thank you very, very much. And now, Honorable Chief Justice, we will hand over the book to our visiting Chief Justices and our Chief Justice as a gift. The book is Beacons of Judicial Transformation. It's a selection of speeches, writings, and opinions.
Thank you so much, Chief Justice. Thank you. What an honor. What an honor. Thank you so much.
Thank you, Chief Justice. there is a critical convening of Africa Judges and Jurists Forum, known as the AJJF, that has really continued to provide a convening continental space, and Chief Justice Emeritus is the chair of the Elders panel. It is also excellent and exceptional to see that there is ample gender representation on the stage. I think that's a celebration, and Africa is leading from the front. Actually, the African continent has a record of the most women chief justices across the world, so something to celebrate about our continent. And we are truly delighted to have. Thank you very much. God bless you. Thank you, Chief Justice. Thank you, Chief Justices. Thank you, Judge President. We will treasure that image for many, many years to come. Allow me to welcome Chief Justice Martha Koome to the launch bay to lead the launch of the Supreme book, the launch of the Supreme Court commemorative book and operational plan for the financial year 2024 to the financial year 2028-2029. I invite our Honorable Deputy Chief Justice to join the Chief Justice on stage. I also welcome our Honorable Judges of the Supreme Court to join the Chief Justice on stage. Our visiting Chief Justices to join the Chief Justice on stage. Honorable Lady Justice Fatuma Sichale representing the Judicial Service Commission, and Honorable Esther Nyayaki representing the Office of the Chief Registrar. I also welcome the Chief Registrar of the Court to join as well. Let's start the order and then Chief Justice Emeritus, please join them. Thank you. There will be pyros, so let's stand further away from the pyros bay. There will be pyros. All right. We are joining the Honorable Chief Justice, Honorable Deputy Chief Justice, Honorable Chief Justices, the Judicial Service Commission, and the Office of the Registrar in witnessing the launch of the Supreme Court commemorative book and operational plan 2024 to 2028. Let us count down. 5, 4, 3, 2, 1. Indeed, 12 years of celebrating the Constitution. 12 amazing years of defending the Constitution and a plan for the future to take the transformative role of the Supreme Court even further. Band, once more, let us appreciate our Supreme Court. These proceedings, as pronounced by the Honorable DCJ and Honorable Chief Justice Emeritus, are officially closed. We may take our seats as we take our national prayer as a closing item. Thank you, band. To translate for the band, they are saying, mambo sawa sawa. Things are okay. Supreme Court ikiwa enzini as the apex court. Things are good. Thank you very, very much. May I request that we be upstanding for the closing national anthem. Thank you very much. We have a brief photo session with the Chief Justice, Chief Justices visiting DCJ, Chief Justice Emeritus, Judge of the Supreme Court, representative of the Judicial Service Commission, and the Office of the Chief Registrar, and the operational plan. And thereafter, we will join the Honorable Chief Justice to visit the displays and thereafter to lunch. Let's that. Yeah. Let's have a proper picture. Just the way you sit, and everybody else. Thank you.
I give all of them.
Yes. After the photo, we will all proceed to the exhibition, and thereafter